Our Heavenly Father, the fount of all goodness and grace, the cause of wisdom, the source of intelligence, we welcome you, O Lord, to this auspicious gathering of your beloved, who continuously give you thanks for every opportunity to learn something new and become fruitful to the works of your creation. We humbly come to you, not because we are worthy, but because we find ourselves in need of you, who is our strength and our hope, to continue despite the challenges we face in health, prosperity, and our solidarity with one another. We pray that today's gathering, made possible by the grace of advancements in technology and social media, becomes successful in its endeavors, so we can offer it back to you as our humble offering to honor you, glorify you, and love you through our deeper connection with everyone. May we find bliss in today's session and become more productive children and co-creators of the earth. This we ask and pray through Christ our Lord. Amen.
Hello, good afternoon everyone, and welcome to Bar Ops Pilipinas 2020-2021, the best bar ever webinar lecture series. I'm Meg Reyes, a graduate of the Ateneo de Manila University School of Law, and I will be your host for today. Before anything else, let me acknowledge the presence of our esteemed law school deans all over the country. Of course, spearheaded by Paul's president, Dean Festin, and chairperson, Dean Mawis. Last August, we already had a series of webinar lecture series. Lahat yon ay for mental preparedness. We kicked off this bar ops with Tara, Kape Tayo, wherein Dean Festin himself gave words of encouragement and inspiration, followed by Ano nga ba ang ginawa ko, with the sharing of experiences of our three handsome law school deans. Of course, there was also a lecture on mental preparedness by Attorney Cayosa. And lastly, Attorney Lardizabal gave tips on how to answer the bar exam with Oo na, sasagutin na kita. If you want to revisit these webinars, they are still available on the Pulse Facebook page. Of course, to our viewers, kumusta kayo? How are you feeling, guys? Especially to our bar takers. How is the preparation going? Comment away on how are you guys feeling today. Of course, also show your school spirit by commenting your school. Ayan, I'll wait for your comments. Of course, as a bar taker myself, we are truly grateful for Pulse and our sponsors for doing this for us. And if you want to show support and some love to Pulse, just send us some stars through this Facebook Live. Now, just 2 months away from the bar exam, we give you a month-long discussion of the jurisprudence this recently decided by the Supreme Court. We welcome you everyone to Caso Discurso, the 4th season. So ano nga ba yung Caso Discurso? Caso Discurso is a lecture series every Monday for the month of September. We will discuss the law school deans, of course, will discuss the recently decided cases by the Supreme Court. And this event is brought to you by the Philippine Association of Law Schools together with the Polytechnic University of the Philippines. Syempre, in collaboration with Central Books and also our event sponsors, Rex Bookstore and My Legal Wiz. To know more about our sponsors, please watch this video.
It is a noble aspiration to want to dedicate one's life in service of those who are oppressed and defenseless against the unfair and the unjust. It is an admirable advocacy in an adult, but it is awe-inspiring for a child to dream of speaking for those who are voiceless, to stand up in defense of the law and the common good. Because while every child dreams of a future, not every child is like you, who dreams of shifting society and change. Professors and
Rex materials helped me in reviewing for the bar exam. Most of the books that I used in law school were published by Rex, and I practically used the same old law books during the bar review, as they were complete and comprehensive. Being then a working student, it was financially hard to buy new books. Good thing, Rex offered these law books at an affordable price. Also, the books published by Rex are known for their quality. The law books that I purchased from Rex and those that I borrowed from the school library, mostly published by Rex, became my strong armor, weapon, and constant companion as I hurdled the challenging life in law school. It is an honor to become part of Rex's family, and I am proud and happy to be with the best publisher in legal education.
Rex Education implements an uncompromised editorial process to ensure quality content. In fact, Rex Education law books have received numerous book centenary awards by the Supreme Court. Because legal education is continuously evolving, Rex Education continuously innovates in legal education. There have been challenges, but Filipinos have always risen above, and we are thankful for the support.
Rex Education's legacy in championing lifelong learning continues despite the changes in the landscape of legal education. And because we recognize those changes, Rex Education is able to provide the appropriate solutions. Rex Education digital products and online platforms made our learning materials more accessible to the learners, which enabled them to have a better grasp of their dreams of becoming a lawyer.
for you who's taking the leap, Rex Education has prelex in preparation for law school admission exam. For you who's uncertain but keeps on striving because your dream is not yours only, but of your family and the society. No matter the challenges, you move forward because every minute means 100 words read. Rex Education has reliable textbooks and codals that you can depend on in your study of law. To your family, Rex Education has borrowed. No more second guessing. Publish your book, and everything that we do is dedicated to helping you succeed because we value you. And your dream of becoming a lawyer and excelling as one. Not just for the past 70 years, but also for the following generations to come. Rex Education will be with you every step of the way.
Yun hong yung grace period doon sa rental sa mga commercial at residential, grace period pala ho ito.
Why not just talk to these hotels, these companies, not to lay anyone off and give the aid to the business?
Cliche, but still, knowledge is power. Knowledge of the law enables us to reason out in an adverse situation. My Legal Whiz is here to empower us.
Speaking on behalf of the law students from Negros Oriental.
Yan yung mga actual questions na sobrang open-ended, hindi masyadong detalyado.
Today, we are introduced to another innovation, the My Legal Whiz and Ask Free Legal Advice or Ask Leia. My Legal Whiz is an innovative online platform for legal knowledge, documentation, and research services that can help our micro, small, and medium enterprises without spending immediately on technical legal references or without getting a professional retainer for their legal issues and queries.
This is going to be very interesting, not only to lawyers but also to all who are in need or will be in need of lawyers. The interesting thing about it, however, is that you may not have to consult a lawyer in person anymore. You simply need to click your gadget and you are able to access legal content that you may need, whether you are a businessman, a legal researcher, or labor and tax professional.
This is regarding the books and resources. Kasi they don't have a Rex bookstore in their area.
Regular employee na siya. However, hindi yun ginrant ng kumpanya na. You are entitled to separation pay of at least 1 month pay for every year of service kapag regular employee ka. Yun yung hinahabol niya. So if you qualify as a regular employee earlier than in 2019, then your separation pay shall also be counted retroactively to cover the earlier years of service as a regular employee.
It's about time that they should be educated on how to address some of these legal concerns, and they can access this through the tip of their fingers with My Legal Whiz online platform. So I would like to thank My Legal Whiz for initiating this roadshow caravan for our businesses to be able to educated on these concerns.
Research at the tip of your fingers, ganyan po kadali ang My Legal Whiz. Kaya nga iniinganyo natin po ang ating mga kababayan, hindi lamang hindi lamang po yung mga eskwelahan sa mga law schools, Attorney M, kahit yung mga private companies, lalo na po mga LGU, mga
LGU sa Attorney G.
Di ba yung mga nasa gobyerno natin, mga ahensya ng pamahalaan, i-try nyo po ito dahil ito po yung malaking tulong sa kung paano po kami nakinabang dito. Ang puntahang legal ay nakikinabang dito, ang mga estudyante ng pamantasan ng Lungsod ng Maynila ay nakikinabang, kayo din po gusto namin makinabang.
Kaya naisipan namin na gumawa o siguro i-maximize natin yung paggamit ng technology. So nakita nga namin itong My Legal Whiz. Dito na kami naghahanap. Nagda-download kami ng mga forms. So wala kami ibang ginagawa kundi pag-download. So fill up na lang namin yung form, re-reviewin na lang namin.
Do sari-sari stores and online shops that have capitalization lower than 20,000 pesos need to print official receipts at the BIR.
We recommend that you still get a BIR certificate of registration and get an authority to print official receipts. Namatay from whom they did not inherit anything kasi wala kang property, pero nakatanggap naman sila sa lolo nila. So ang kadagdagan na kaalaman lang po.
Again, thank you, PALS and PUP College of Law in collaboration with Central Books, and also our event sponsors, Rex and My Legal Whiz. Of course, I would like to acknowledge those who commented from our viewers. We have viewers from DMMSU La Union, also from St. Mary's College of Tagum. We also have viewers from University of Cagayan Valley, viewers from University of the East and PUP Bar Review Center. We also have viewers from University of Nueva Cáceres, Bicol. Keep your comments coming, guys, and later on, you can post your questions also through the comments. Again, please don't forget to send some stars through our Facebook Live. Now, to officially welcome us and our speaker for today, everyone, the Dean of the PUP College of Law and the President of the Philippine Association of Law Schools, Dean Jemmy Lito Festin.
Thank you, Meg. Good afternoon, everyone. Dear participants from different law schools, welcome to another series brought to you by the Philippine Association of Law Schools Best Bar Ops 2021. On our last webinar for the month of August, you were taught how to spot issues and answer bar questions, and you were taught by none other than Attorney Judy Larguisama. So this month, as we enter the Bear months and get closer to the best bar ever, we give you the 4th edition of Caso Discurso, a discussion of the latest decisions penned by the Supreme Court. This is the 4th year of partnership between PALS and the PUP College of Law. One of the best ways to understand and remember the law is to have a close reading of the case decisions and to discuss about it. For this edition of Caso Discurso, you will hear and learn from the most prominent law school lecturers, the deans, and this will be to your advantage. So don't miss it every Monday. Today, the bar subject is remedial law, and our guest speaker is an expert in the field. She is our PALS chair. So stay tuned and absorb everything you can. Thank you very much. And once again, welcome to the Best Bar Ops 2021's Caso Discurso 4th edition. God bless everyone.
Thank you very much, Dean Festin. Now, to our bar takers, we are just 61 days away from the bar. Yes, that's right, 61 days or 2 months. What better way to prepare than to review the latest jurisprudence decided by the Supreme Court? And of course, it will really be helpful if we start with the heaviest bar subject, that is remedial law. So without further ado, help me in welcoming online our speaker for today. She had her undergraduate in law studies from the University of the Philippines. She earned her political science degree in 1983 and graduated cum laude. In the year 1997, she finished her law degree and ranked 15th in her class. Our esteemed speaker is also a member of the Civil Law Department and a professional lecturer at the Philippine Judiciary Academy. She's also a law professor in the Colleges of Law of Lyceum of the Philippines, University of the Philippines, De La Salle University, University of Santo Tomas, and Adamson University. A bar reviewer in persons and family relations, civil procedure and evidence at the UP Law Center, Academicus, and Villasis Review Center. She's also a MCLE resource person and founder of the Maui's Law Office. She is also a columnist of the Philippine Daily Inquirer and a subject matter expert at the IDLO DOJ project on the prosecution of crimes involving women and children. Also, a co-author of Persons and Family Relations. Everyone, please welcome online our speaker for today, the Dean of the College of Law of the Lyceum of the Philippines University and the Chairperson of the Philippine Association of Law Schools, Dean Maria Soledad Berequito Mauis.
Magandang hapon sa inyong lahat. I'm very, very sure that you're very excited to take the bar in about, less than 2 months. And thank you for attending this. We are with you in your journey, so allow us to share with you the little things we know about our topic, the topic assigned to us. So maybe we can start now. Is Attorney Philip with us? So that he can start sharing the slides, please. Attorney Philip? Okay, there you are. Okay, the topic assigned to me today is remedial law, but the focus this will be on more on civil procedure. Okay, now let's start with a more important one, and that is jurisdiction. Okay, Philip. Okay, we all know that jurisdiction is the power and authority of the court to hear and decide a case, and jurisdiction over the subject matter cannot be subject to the will of the parties. Why? Because it is decided by law. It is based on law. Okay. It cannot be subject agreed upon by the parties. Now, jurisdiction over the subject matter will depend upon the allegations of the complaint and never based on the defense raised by the defendant in his answer. Now, let's first discuss this case of Attorney Garcia versus Court of Appeals. In the case of Attorney Garcia versus Court of Appeals, the Supreme Court said that an original action for injunction is outside the jurisdiction of the Court of Appeals. Okay? However, under BP 129, the Court of Appeals has original jurisdiction only over actions for annulment of judgments of the RTC's decision and has original jurisdiction to issue writs of mandamus, prohibition, certiorari, habeas corpus, and quo warranto, and the auxiliary writs of the processes, whether or not they are in aid of its appellate jurisdiction. The appellate court jurisdiction to grant a writ of preliminary injunction is limited to actions or proceedings pending before it. So therefore, if the RTC had used its discretion in issuing a writ of execution, the petitioner should have challenged the same through a Rule 65 petition. Please take note that in the case of Attorney Garcia, nag-file ng original petition, okay, mismo dun sa Court of Appeals for injunction. Iba po ang injunction at iba po ang prohibition. Ang injunction po, ang may original exclusive jurisdiction po niyan ay RTC because that is an action incapable of pecuniary estimation. Now, let me now go to the second case, which was decided in February 2020, and this is the case of Tomadaos versus San Miguel Yamamura Packaging. Okay. Now, in the case of Tomadaos versus San Miguel Yamamura Packaging, petitioner availed of the company's involuntary separation program. His employer withheld an amount on behalf of the cooperative kasi sabi ng cooperative, o may utang sa amin yung employer na yan. Kaya kung anong ibibigay mo siya sa kanya, kumbaga parang retirement niya, please hold on to this amount. No? So his employer withheld that amount on behalf of the cooperative, to which petitioner allegedly had an outstanding indebtedness. Petitioner then filed a complaint before the NLRC arbitration branch for non-payment of separation pay and damages. The labor arbiter rendered ordering the respondent corporation to pay the amount withheld and damages, and the NLRC on appeal upheld the judgment. Now, on certiorari under Rule 65, the Court of Appeals nullified the decision of the NLRC because according to the Court of Appeals, the NLRC does not have jurisdiction over the subject matter. Now, what did the Supreme Court say? Not all controversy involving money claims by an employee against an employer or vice versa will necessarily fall within the jurisdiction of the labor arbiter. With regard to money claims and damages, Article 224, formerly 217 of the Labor Code as amended, bestows upon the labor arbiter original and exclusive jurisdiction over cases filed by workers involving wages, among others, if accompanied, okay, by a claim for reinstatement. All claims except those for employees' compensation, Social Security, Medicare, and maternity benefits arising from employer-employee relations involving an amount exceeding 5,000 pesos, regardless of whether accompanied with a claim for reinstatement and claims for actual moral damages, exemplary, and other form of damages arising from employer-employee relationship. Now, with respect to this case, the jurisdiction of the LA over money claims and damages is confined to those cases which are either accompanied by a claim for reinstatement or arising from employer-employee relationship. Here, the court finds that the petitioner's claims do not fall under any of these cases. Dahil ang kinukuha niya ay yung winidhold ng employer bilang kabayaran dun sa sinasabing utang sa cooperative. So sabi ng Supreme Court, walang jurisdiction ang labor arbiter dyan. Why? Because petitioner claims have no reasonable causal connection with his employment relationship with the respondent. It bears to point out that the case that the petitioner filed was neither a complaint for illegal dismissal nor a claim for reinstatement. His complaint was for alleged non-payment of separation pay, because precisely it was withheld to pay the alleged debt due and owing to the cooperative. Now, respondent even paid out petitioner's separation package, except that it withheld an amount purportedly, what representing his representing the unpaid, representing the amount he owed the cooperative. Petitioner in turn signed a receipt and release in favor of the respondent, but made notation that he withheld was still subject to verification. Thus, by signing the receipt and release, petitioner had in fact acknowledged that he had been paid all amounts due him comprising his separation benefits, except that he questioned the withheld amount as he claimed that he no longer had any existing loan or obligation to the cooperative. It thus appears that the principal relief sought by petitioner in his complaint was not the payment of separation package, but the release to him of the withheld amount which both he and the cooperative claimed interest. Dapat daw, ang sabi ng Supreme Court dito, ang ginawa ng employer ay the employer should have filed an interpleader case. Now, let me now go to the case of Philippine-Japan Active Carbon Corporation versus Habib. It's a 2020 case again. Now, the petitioner in this case leased 2 apartment units from the respondent. The 2 lease contracts have a lease period, and to secure faithful compliance of the obligations of petitioner under the lease contract, a security deposit was paid. Petitioner deposited the required security deposit for the 2 apartment units. The lease contract was not renewed after the expiration. After vacating the premises, petitioner asked respondent to return the security deposit. Respondent refused, alleging that petitioner failed to comply with its obligations in the lease contract, such as keeping the units clean. So petitioner filed an action for collection of sum of money with the MTCC. Said court ruled in favor of the petitioner. RTC, however, reversed the ruling of the MTCC. RTC held that respondent had the right to withhold the deposit until his claim for damages to the units, which were not caused by ordinary wear and tear, have been reimbursed. Now, the Court of Appeals, however, dismissed the complaint on the ground that the MTCC does not have jurisdiction. The Court of Appeals ruled that the allegation in petitioner's complaint make out a breach of contract, and therefore an action for specific performance is an available remedy. So, because it is an action incapable of pecuniary estimation. Yung amount po kasi ng security deposit is within the jurisdictional amount of the MTCC. So, ang sinasabi basically ng Court of Appeals, but you're enforcing the contract. So, therefore, even if that is that amount, the fact of the matter is the nature of the action you filed is really one for specific performance. And therefore, it should have been filed with the RTC, because the issue of a specific performance is what? It's a case now, according to the Court of Appeals, it's a case of breach of contract. Therefore, it is incapable of pecuniary estimation. Therefore, it should have been filed with the RTC. Okay. Now, according to the Supreme Court, in order to determine whether the subject matter of an action is one which is capable of pecuniary estimation, the nature of the principal action or remedy sought must be considered. If it is primarily for recovery of sum of money, then the claim is considered an action as capable of pecuniary estimation, and the jurisdiction lies with the proper court depending on the amount sought to be recovered. However, where the basic issue of the case is something other than the right to recover sum of money, where the money claim is merely incidental to the principal relief sought, then the subject matter of the action is not capable of pecuniary estimation and within the jurisdiction of the court. You know, the CA, according to this case, was mistaken according to the Supreme Court. Contrary to its ruling, a perusal of the complaint filed by the petition makes out a case for collection of sum of money and not for breach of contract. It should be noted in the facts I mentioned earlier that the lease agreement had already expired when petitioner filed an action for the return of the security deposit. Since the lease had already expired, there is no more breach of contract or contract to breach because tapos na yung kontrata. So the demand for the return of security was merely a collection suit. What petitioner prayed for before the MTCC was the return of the 90,000 pesos, okay, which represented the security deposit, and not to compel respondent to comply with this obligation under the lease agreement, which, by the way, had already expired. As such, the CA erred when it held that the MTCC has no jurisdiction over the case and dismissed the same for lack of jurisdiction. Okay, before I proceed with the next topic I will discuss, minsan kasi talagang mahirap mong sometimes it's difficult to really discern whether the case is a simple collection case or it's really an action of incapable of pecuniary estimation, yung tipong specific performance. So maybe, my suggestion is, given that you know na how the Supreme Court, the examiners will check it, state the principle, okay? If you're medyo alanganin, state the principle, at least you will have points and then apply it. So in this particular case, my suggestion is you put the principle in order to determine whether the subject matter of an action is one which is capable of pecuniary estimation, the nature of the principal action or remedy sought must be considered. Okay. Attorney Philip, can you bring it back to slide 10, please? If it is primarily for recovery of sum of money, then the claim is considered as capable of pecuniary estimation and the jurisdiction lies with the proper court depending on the amount sought to be recovered. But if the basic issue of the case is something other than the right to recover a sum of money, where the money claim is merely incidental to the principal relief sought, then the subject matter of the action is not capable of pecuniary estimation and it is within the jurisdiction of the RTC. So if the question is, it involves capable ba yan of pecuniary estimation or incapable ba yan of pecuniary estimation, yun na muna ang isulat nyo. Okay, at least definitely you will have points because you got a principle right. Okay, and then apply it. Okay, as I said, this is one of the principles in jurisdiction na, even lawyers are having difficulty, discerning whether is this an action capable of pecuniary estimation or an action incapable of pecuniary estimation. Okay, now, let me now discuss briefly small claims. Okay, small claims. For payment of money where the value of the claim does not exceed 400,000 pesos for the METCs and 300,000 pesos from the MTCCs, MTCs, MCTCs, exclusive of interest and cost. Okay? Dapat sa computation ng small claims, huwag niyo pong isasama yung interest. Huwag niyo pong isasama yung iba pang damages. Okay? Ngayon, saan applicable ang small claims? All actions which are purely civil in nature where the claim or relief prayed for by the plaintiff is solely for payment or reimbursement of sum of money. And the reason why I want to stress this is because of this, no? The claim may be owed under a contract, lease, loan, services, sale, mortgage for liquidated damages arising from contracts, the enforcement of a barangay amicable settlement or arbitration award involving a money claim covered by the rule. Okay. If you will notice, wala po yung exemplary. Kunwari, ang kaso is nabangga kayo ng jeep. Okay? Pag nabangga kayo ng jeep, punta kayo sa ospital, mga 300,000 ang nagastos nyo. Hindi po yan magiging small claims. Because if you will notice, based on the applicability or the scope, small claims will apply for money owed under a contract, lease, loan, services, sale, mortgage. And then you have liquidated damages, which is stated in the contract. And please take note, when it comes to the enforcement of a barangay amicable settlement, the amount should likewise be 400,000. So kunwari po, 300 o 200,000 ang inyong nagastos pa hospital dahil nasagasaan kayo ng bisikleta. Hindi po siya small claims. You will have to file it still with the MTC, but the procedure that will be followed will be the revised rules of summary procedure. Okay. Now, where do you file it? Where the plaintiff, the person suing, resides, or the defendant resides, or if the plaintiff is in the business of lending, banking, and similar activities in the city where the defendant resides, if the plaintiff has a branch in that city. Okay? Now, let me just briefly discuss small claims lang, no, in a capsulized form. You file a verified statement of claim. Okay, of course, you have a certification of non-forum shopping, and all your actionable documents, you attach it to the statement of claim. We don't call it a complaint. No? It's a statement of claim. Of course, you have to pay the docket fees and other legal fees. The first thing the court will do is examine the claim. The court has the power to dismiss it if it has no jurisdiction to hear and decide the case. Now, if there's no ground for dismissal, okay, the court shall issue summons on the day of receipt of the statement of claim, directing the defendant, okay, to file a verified response. Now, hindi po answer ang tawag, response po. Now, if the defendant cannot be served with summons, the court shall order the plaintiff to cause the service of summons within 30 days from notice. Otherwise, the case will be dismissed. Notice issued directing the parties to appear before it on a specific date and time for hearing with a warning that no unjustified postponement shall be allowed. Okay. Now, the defendant in a small claims case has a non-extendable period of 10 days from receipt of summons within which to file his response. And the response shall be accompanied by certified photocopies of documents as well as affidavits of his witnesses. And then the parties will appear at the designated date. Please take note, okay, that if it's a corporation, the corporation plaintiff or corporation defendant, okay, must be, the representative must be authorized under a special power of attorney. No lawyer can appear to represent a party. So at the hearing, the first thing the judge will do is exert efforts to bring the parties to an amicable settlement. If the case is settled, then whatever settlement arrived upon by the parties will have to be reduced in writing and it will be approved by the court, if the same is not contrary to law, public policy, or morals. Now, if no settlement is reached, the hearing shall so proceed in informal and expeditious manner and terminated on the same day. And then after the hearing, the court shall render its decision within 24 hours from the termination of the hearing. And this is very important. The decision in the small claims court is immediately final and executory. Okay? And I will discuss that, why that is very important. Now, can you join claims? The answer is yes. Plaintiff may join in a single statement of claim one or more separate small claims against a defendant, provided that the total amount claimed, again, exclusive of interest and cost, does not exceed 400,000 pesos. Now, the affidavits that must be submitted, okay, shall state only facts of direct personal knowledge of the affiants which are admissible in evidence. A violation of this requirement shall subject the party and counsel who assisted the party in the preparation of the affidavits to appropriate disciplinary action. Now, let me focus on the response. The response, as I said, should be filed by the defendant within a period, by the respondent rather, within a non-extendable period of 10 days from receipt of summons. And it should be accompanied by certified photocopies of the documents as well as affidavits of witnesses and other evidence in support thereof. No other evidence shall be allowed during the hearing which was not attached to or submitted together with the response unless good cause is shown for the admission of additional evidence. But even if the defendant failed to file a response, he will not be declared in default. Okay. Should the defendant fail to file his response within the required date, the court by itself shall render judgment as may be warranted by the facts alleged in the statement of the claim, limited, however, to what is prayed for. But the court, however, may in its discretion reduce the amount of damages for being excessive or unconscionable. Pwede po ba tayo maglagay dyan ng counterclaim? Opo, pwede ho tayo maglagay ng counterclaim yan. However, subject to certain rules. If at the time the action is commenced, the defendant possesses a claim against the plaintiff, that it is within the coverage of this rule, exclusive again of interest and cost, it arises out of the same transaction or event that is the subject matter of the plaintiff's claim, it does not require for its adjudication the joinder of third parties, and it is not the subject of another pending action, then the claim shall be filed as a counterclaim in the response. Otherwise, the defendant shall be barred from suit on the claim. Which means, pag meron po tayong compulsory counterclaim, kailangan ho nating isama yan sa response, otherwise deemed barred. Also, how about permissive counterclaims? The defendant may also elect to file a counterclaim against the plaintiff that does not arise out of the same transaction or occurrence, provided that the amount and nature thereof are within the coverage of this rule and the prescribed docket and other legal fees. So pwede ho kayo mag-set off, okay? Pero pag set off, doon pa rin ho sa ang amount, hindi lalagpas doon sa amount pang small claims, which is 400, no? Pag sumobra na ho yun, you cannot insist, okay, for the court to dismiss the complaint by applying the set-off and ask for the amount in excess, let's say, of 400,000, because wala nang jurisdiction ang court doon, no? So you can use your permissive counterclaim just to show that you can set it off so that you can have the complaint dismissed. Now, because it is a permissive counterclaim, then yung excess nun, pwede mong i-file sa panibagong complaint in the proper court. Now, if you will notice, in small claims, in revised rules and summary procedure, and in ordinary civil action now because of the 2019 amendments to civil procedure, lahat mayroon ng prohibited pleadings. Okay. Under small claims, the following pleadings, motions, or petitions shall not be allowed. Motion to dismiss the statement of claims, motion for bill of particulars, motion for new trial or reconsideration of a judgment, which means the final order of judgment, or for the reopening of the trial. Petition for relief from judgment, motion for extension of time to file pleadings, affidavits, or any paper, memoranda, petition for certiorari, mandamus, prohibition, motion to declare defendant in default, dilatory motions for postponement, reply, third-party complaints, and intervention. Again, uulitin ko lang po, lawyers are not allowed in small claims court. Okay. Earlier, I said that the decision of the RTC acting as a small claims court is immediately final and executory. And that's the reason why in AL Network versus Mondihal, the Supreme Court said, given that the decision of a small claims court is final and unappealable, Considering the final nature of a small claims case decision, the remedy of appeal is not allowed, and the prevailing party may thus immediately move for its execution. Nevertheless, the prescription on appeals in small claim cases, similar to other proceedings where appeal is not an available remedy, does not preclude the aggrieved party from filing a petition for certiorari under Rule 65 of the Rules of Court. Remember that the extraordinary writ of certiorari is always available where there is no appeal or any other plain, speedy, and adequate remedy in the ordinary course of law. Okay. Now, since diniscuss ho natin yung small claims, discuss na rin ho natin kahit maghahagya lamang yung revised rules on summary procedure. Okay. Now, again, this rule shall govern the summary procedure in the MTC, the Municipal Trial Courts in cities, the MTCs, and the Municipal Circuit Trial Courts in the following cases falling within its jurisdiction. So if I may just interject this, no? Kung papansin niyo, in pinaka-inferior court nga yung Metropolitan Trial Court, MTCs, at saka MTCs, and the MCTCs. Pero yung inferior court na yan, basically, tatlo ang ina-administer at ini-implement niyang procedural rule. You have small claims, you have revised rules on summary procedure, and then you have ordinary rules on ordinary civil actions. So when you read a problem in the bar, the very first thing you will ask yourself, pang ano ba to? Pang small claims ba to? Pang revised rules on summary procedure ba to? O pang ordinary civil action? Yun ang una po niyong titignan. Now, what is the scope when you talk about revised rules on summary procedure? In civil cases, all cases of forcible entry and unlawful detainer, respective of the amount of damages or unpaid rentals sought to be recovered. So if I file, let's say, an unlawful detainer complaint and I'm asking for 2 million by way of arrears for defendant to pay me, still the jurisdiction will lie with the MTC. Or where the attorney's fees are awarded, the same shall not exceed 20,000 pesos. All other cases, except probate proceedings, where the total amount of the plaintiff's claim does not exceed 100,000 pesos or 200,000 pesos in Metropolitan Manila, exclusive of interest and cost. Okay. Siguro tinatanong nyo, paano kaya yung expanded jurisdiction, okay, ng MTC? Kasama ba yan sa bar? Well, ako, I personally, I believe, and I really believe when the Honorable Associate Justice Leonen said may cut-off and he will follow the cut-off, hindi masasama yan kasi kailan lang naman nagkaroon tayo ng expanded jurisdiction. Okay? So I don't think it will be included in the bar. And now for criminal cases, violation of traffic rules and regulations, violations of the rental law, violations of the municipal or city ordinances, and all other criminal cases where the penalty prescribed by law for the offense charged is imprisonment not exceeding 6 months or a fine not exceeding 1,000 pesos or both, irrespective of other imposable penalties, accessory or otherwise, or of the civil liability arising therefrom. Provided, however, that in offenses involving damage to property through criminal negligence, this rule, the rules on revised summary rules on procedure, shall govern where the imposable fine does not exceed 10,000 pesos. Now, this rule shall not apply to a civil case where the plaintiff's cause of action is pleaded in the same complaint with another cause of action subject to ordinary procedure, nor to a criminal case where the offense charged is necessarily related to another criminal case subject to the ordinary procedure. Bakit hindi ho siya pwedeng ipagsama? Kung tutuusin naman ho, basic naman ho, miskin nga alternative causes of action, pwedeng isama. Kaya hindi ho siya pwedeng isama dahil iba po ang rules ng revised rules and summary procedure, ibang rules po yung ordinary civil action. Okay. In fact, sa pag-file lang ng answer, pag revised rules and summary procedure, non-extendable period of 10 days. Whereas sa ordinary civil action, anong rules niya doon? 30 days, okay, 30 calendar days from your receipt of the summons if it was personally served upon you. So let me just briefly discuss the procedure in a nutshell. Okay. Now, here's your complaint. The first scenario, no answer was filed. Can you file a motion to declare defendant in default? Hindi po. Now, the judge motu proprio, the court motu proprio, or upon motion of the plaintiff, can you just file a motion to render judgment based on the complaint. At ang titignan lang ho doon, meron bang cause of action? Tama ba yung lahat na nakasama ba doon sa complaint? No? Kung may cause of action. At meron, may judgment. Pero ang judgment, hindi pwedeng lumagpas. Okay? Doon lang it is as pleaded kung ano lang yung hiningi. Now, on the other hand, this is your second scenario, if an answer is filed, and you know the answer has to be filed within 10 days from service of summons, pagkatapos nun may preliminary conference. Okay. Pagkatapos ng preliminary conference, mag-i-issue ng court ng preliminary conference order. And within 10 days from your receipt of the preliminary conference order, then the party is supposed to submit within 10 days from receipt of said order their position papers. Okay? And then, can the court conduct hearing? Okay? No, the court cannot conduct a hearing. But it can conduct clarificatory hearing only if necessary. Okay? And then after that, judgment will be rendered. Okay? So what is the failure or what is the effect of failure to file an answer? Should the defendant fail to file an answer, the complaint within the period above provided, which is a period of 10 days from receipt of the summons, the court on its own or on motion the plaintiff shall render judgment as may be warranted by the facts alleged in the complaint and limited to what is prayed therein. Provided, however, the court may in its discretion reduce the amount of damages and attorney's fees claimed for being excessive or otherwise unconscionable. Now, may sentence dito. This is without prejudice to the applicability of Section 4, Rule 15 of the Rules of Court if there are two or more defendants. Kung matatandaan po ninyo, ito ho yung prinsipyo na one plaintiff, for example, one plaintiff, two defendants. And these two defendants were sued under the same cause of action. Okay. One of the defendants, let's call them B. B now filed an answer. Okay. C did not file an answer. Now, can the judge on its own or can the plaintiff file a motion for the court to render judgment based on the complaint against C, considering that C did not file an answer? The answer is no. Why? Because they are being sued, okay, under the same cause of action. Kakaroon ng prejudgment kung magkakataon. So in other words, as long as the defendants are being sued under the same cause of action, okay, the non-answering defendant will benefit from the answer filed by the answering defendant. Okay, I have already briefly discussed preliminary conference. Allow me please to just discuss referral to the lupon. When there is no showing of compliance with such requirement, and that is your barangay justice system, the complaint shall be dismissed without prejudice. It may only be revived only after such requirement shall have been complied with. But this provision shall not apply to criminal cases where the accused was arrested without a warrant. Okay. Now, as I said, small claims, revised rules and summary procedure, and of course, ordinary civil procedure now have this section on prohibited pleadings. Under the revised rules on summary procedure, you cannot file a motion to dismiss the complaint or quash the information except on the ground of lack of jurisdiction over the subject matter or failure to comply with the barangay conciliation law. You cannot even file a motion for extension of time to file an answer. You cannot file a motion to declare defendant in default. You cannot file a petition for relief from judgment, even third-party complaints, etc. Okay. Now, Once a judgment has been rendered by the MTC pursuant to the revised rules and summary procedure, this time the judgment or final order shall be appealable to the appropriate RTC. Okay, the decision of the RTC in civil cases governed by this rule, including forcible entry and unlawful detainers, shall be immediately executory, without prejudice to further appeal that may be taken therefrom. Okay, let me just discuss briefly. No, so if the MTC renders a judgment in favor of the lessor plaintiff, okay, the lessee appeals, okay, technically the decision of the MTC is immediately executory, notwithstanding the fact that the decision was appealed to the RTC. The only way the defendant can stop, okay, the execution, immediate execution, is of course file a notice of appeal. You put up your supersedeas bond if the judgment talks about payment of arrears, and of course you have to do your usual periodic monthly rentals while the case is pending appeal before the RTC. But once the RTC has decided and the decision is in favor, okay, of the, again, plaintiff lessor, and the plaintiff lessee and defendant lessee appeals it to the Court of Appeals via Rule 42, that is really immediately executory, okay, without prejudice to the appeal to the CA. Okay. Procedure in criminal cases, how it's commenced, okay. The filing of criminal cases falling within the scope of this rule shall be either by the complaint or by information, provided, however, that in metropolitan Manila and chartered cities, okay, ang mangyayari dyan, dadaan pa rin yan sa public prosecutor. Okay, now, let me just discuss now the case of Lucas versus Fabros. As a rule, a motion for reconsideration is a prohibited pleading under Section 19 of the revised rule on summary procedure. It's very clear from Section 19. However, the order subject of this case is actually an interlocutory order. Okay? Nag-file siya ng MR against an interlocutory order. So anong sabi ng Supreme Court sa kasong ito? Pwede daw kayong mag-file ng motion for reconsideration against an interlocutory order, because if you read Section 19C, okay, the prohibited pleading is a motion for reconsideration against a judgment or a final order, which means this rule applies only where the judgment sought to be reconsidered is one rendered on the merits. Okay. We have the 2020 case of Garcia versus Esguerra, spouses Esguerra, where the Supreme Court said, under the revised rules and summary procedure, the weight of evidence is not considered when a judgment is rendered based on the complaint. Bakit po? Kasi hindi naman ho kayo katatawag ng witnesses. Pagbabatayan nyo lamang kung anong nakasagot dun sa complaint. So here, petitioner's failure to timely file his answer to the complaint constitutes her acquiescence to all of the allegations stated therein. Okay. Consequently, there's actually nothing else to be done in this situation except to render judgment as may be warranted by and based solely on the facts alleged in the complaint. Okay. Now, I am just compelled, okay, to share with you just important provisions on the 2019 Rules on Civil Procedure. Kasi dahil bago yung 2019 Rules of Procedure, wala pang nakakarating na kaso sa Supreme Court sa aking pagkakaalam on the basis of the amendments introduced by the 2019 Rules on Civil Procedure. And I remember I asked before the Honorable Associate Justice Yone, ano kaya yung itatanong, no? I mean, nung panahon na akala ko noon magkakaroon ng bar exam, I remember he said it's going to be textual. So my suggestion to you who will take the bar, please take note of the new amendments, okay? And it has to be based on text, no? It's going to be textual. So that's the reason why I will just discuss some of the, how would I put it, more or less important innovations introduced. Meron akong hindi nasama dito because it will take again, another session to discuss the changes. But let me just bring you the highlights. No? Reply, okay, you can only file a reply. So you have a complaint, answer, reply. You can only file a reply if you want to deny the due execution and authenticity of an actionable document which served as a foundation of the answer. Okay, now, if there's no actionable document, therefore, or you don't need to deny the due execution and authenticity of the said actionable document, what will happen? Okay, don't file a reply. Okay, hindi na kayo pwede mag-file ng reply. Ang susunod na tanong, paano kung may new matters inalleged sa answer? Then what you have to file according to Section 10 is either an amended or supplemental complaint. If you want to address the new matters that were raised in the answer but is not founded on an actionable document, or if it is founded in an actionable document, you do not intend to deny the due execution and authenticity thereof. Okay. Now, Rule 7, Section 6, contents. Okay. Every pleading stating a party's claims or defenses shall, in addition to those mandated by Section 2, Rule 7, state the following. Name of the witnesses who will be presented to prove a party's claim or defense, summary of the witnesses' intended testimonies, provided that the judicial affidavits of said witnesses shall be attached to the pleading and form an integral part thereof. Only witnesses whose judicial affidavits are attached to the pleading shall be presented by the parties during the trial, except if a party presents meritorious reasons as basis for the admission of additional witnesses. No other witness or affidavit shall be heard or admitted by the court, and documentary and object evidence in support of the allegations contained therein. Because of this, now we can truly say that your pleading must be based on ultimate facts and evidentiary facts. Okay. Again, what is an ultimate fact? It is a fact that you cannot strike off, because if you strike it off, what will happen? You have no cause of action. What will be your evidentiary facts? Those facts that will support, your ultimate facts. Okay. At napaka-importante po yung sinabi dito, dapat pag-file pa lang ng complaint, pag-file pa lang ng answer, nakapaloob na ang judicial affidavits. So may nagtanong, paano yun? Paano na yung judicial affidavit rule? Where you can file your judicial affidavit within 5 days within a period of 5 days before the scheduled pre-trial conference. Well, as being practiced, we can still file the judicial affidavits. Basta ang ano lang dyan, ilagay mo doon sa iyong complaint and answer. Anyway, you can say that you will submit it 5 days before the hearing, before the pre-trial conference. In fact, I will discuss later when we hit Rule 18, okay, may paraan para ka mag-reserve at kailangan ka mag-reserve para yung mga additional witnesses mo makapasok. Okay, now this is to my mind, one of the more important provisions of the 2019 innovations. Okay, remember that Rule 16 of the old rule, it was Rule 16, motion to dismiss, was totally taken out. It was repealed. Okay, now anong nangyari doon? Yung mga grounds sa motion to dismiss, kung saan na siya napunta. Okay. Pagdating dun sa lack of jurisdiction over the subject matter, litis pendentia, res judicata, and prescription. Yan, you can raise it in a motion to dismiss pursuant to Rule 15. Okay. But all the rest, they are now considered as affirmative defenses. A defendant shall raise his or affirmative defenses in his or her answer, which shall be limited to the reasons set forth under Section 5B, Rule 6, and the following grounds. Ano ba yung Rule 6, 5B? Yan yung payment, yan yung estoppel, okay, statute of limitations, etc. Okay? Now, aside from those grounds mentioned in Rule 6, 5B, you can also raise by way of affirmative defenses that the court has no jurisdiction over the person of the defending party, which means improper service of summons. The venue is improperly laid. Plaintiff has no legal capacity to sue. Pleading asserting the claim states no cause of action, and a condition precedent for the filing of the claim has not been complied with. Okay. Failure to raise these affirmative defenses at the earliest opportunity shall constitute a waiver thereof. At ano yung earliest opportunity? Sa answer po yun. Now, notice that the court shall motu proprio resolve the above affirmative defenses. So ito, the court will just resolve it without even setting it for hearing. In fact, wala na po yung rule na kailangan na meron kang notice of hearing. Wala na po yun. Because here the court shall motu proprio resolve the above affirmative defenses within 30 calendar days from the filing of the answer. As to the other affirmative defenses under the first paragraph of 5B Rule 6, the court may, nasa discretion po ng court, conduct a summary hearing within 15 calendar days from the filing of the answer. So if what you raised, let's say, by way of affirmative defense is that the claim has been abandoned, this is extinguished, or otherwise been paid, okay, the court may set the case for hearing. Such affirmative defenses shall be resolved by the court within 30 calendar days from the termination of the summary hearing. And this is very important. Affirmative defenses, if denied, shall not be subject to a motion for recon, petition for certiorari prohibition, or mandamus, but may be among the matters to be raised on appeal after the judgment on the merits. Which means, okay, what is your remedy if your affirmative defense is if your affirmative defenses are denied? Your remedy should go to trial. And then after going to trial, tapos natalo po kayo, pwede ho kayo mag-appeal, at dun po sa appeal nyo, i-raise nyo as one of the assigned errors yung denial ng inyong affirmative defense. Okay, now, Rule 6, Section 5, Defenses. Okay. Affirmative, look at your section, Rule 5, Section 6, no, which was referred to earlier. Affirmative defenses may also include grounds for the dismissal of a complaint. Specifically, the court has no jurisdiction over the subject matter, that there is another action that pending between the parties for the same cause, or that the action is barred by prior judgment. So all these three, you can also raise it by way of affirmative defense. But these three, okay, can be pleaded in a motion to dismiss. Now, the other affirmative defenses, fraud, statute of limitations, release, payment, illegality, statute of frauds, estoppel, etc., you also include that in your affirmative defense. Okay. Now, I've discussed, okay. Now, let me just briefly discuss third-party complaints, no? Okay. Notice that in this particular provision, okay, the third-party complaint shall be denied admission, and the court shall require the defendant to institute a separate action where the third-party defendant cannot be located within 30 calendar days from the grant of such leave. What is important about this is this one. You file a motion to admit third-party complaint. It was granted. Granted siya. Nag-issue ngayon ng summons. Okay? Pero hindi ma-serve yung summons. So the court can still what? Deny admission of the third-party complaint. Okay? And just will require the defendant to institute a separate action para hindi tumagal yung main case. Or if the third-party complaint will introduce extraneous matters to the issue in the principal case, denied din yan. Or the effect would be to introduce a new and separate controversy into the action. Okay. Now, lagay ko dumoble ito. Okay. Just give me a minute because dumoble. Okay. Now, as a rule, a motion for extension of time, pansinin po nyo sa small claims, sa revised rules and summary procedure, bawal yan. Pero sa ordinary rules and civil actions, pwede, pero one time lamang. A defendant may, for meritorious reasons, be granted an additional period of not more than 30 calendar days to file an answer. So the period to file an answer actually will depend how summons was served. No? But if summons was served personally or by substituted means, 30 calendar days. A defendant is only allowed to file one motion for extension of time to file an answer. A motion for extension to file any pleading other than an answer is prohibited. So you cannot file a motion for extension to file a reply because that's already prohibited. and will be considered a mere scrap of paper. Okay. Now, other innovative measures that were introduced, okay, in the 2019 rules. Okay, the filing of pleadings and other court submissions shall be made by submitting personally the original thereof, plainly indicated as such to the court, sending them by registered mail, sending them by accredited courier, or transmitting them by electronic mail or electronic means as may be authorized by the court in places where the court is electronically equipped. One thing for sure, and one thing that's very clear, before you can do your service or the filing via electronic means, it has to be first approved by the court. Okay? Now, service by electronic means and facsimile shall be made if the party concerned consents to such mode of service. So pagdating sa electronic service, okay, filing with court approval, service to the party via electronic means, it has to be agreed upon by the parties. Okay. Now, this also is very important. Presumptive service. There shall be presumptive notice to a party of a court setting if such notice appears on the records to have been mailed at least 20 calendar days prior to the scheduled date of hearing, and if the addressee is from within the same judicial region of the court where the case is pending, or at least 30 calendar days if the addressee is from the court, from outside the judicial region. Ano po yung example niyan? Kunwari po na hearing, nakatanggap ako ng hearing. Ang hearing daw is scheduled on the 25th of, let's say, September. Okay, September. Okay. Now, pagdating ko sa korte, wala yung kalaban ko. Okay, and dala ko na yung witness ko. Sayang naman yung punta namin doon kung hindi ko maprepresenta. So what will I do? The very first thing I will do is look at the records of the case. What's the notice setting the case for hearing on the 25th? Mailed at least 20 calendar days prior to the 25th. And if it appears that it was mailed at least 20 days prior to the scheduled hearing date, then when the court calls my hearing, then I can invoke this presumptive service so that I will be able to present my witness. But this 20-day calendar days rule applies when the addressee, okay, yung kalaban mong abogado, is from within the same judicial region of the court where the case is pending. So if the hearing, let's say, is RTC and Makati, tapos yung opposing counsel ay Makati, I can invoke this presumptive service using the 20-day calendar day period. But if, for example, the opposing counsel is, let's say, from Calamba, Laguna, which is not within the same territorial jurisdiction of RTC Makati, then the period will be 30 calendar days. Okay. Okay. Now, notwithstanding the foregoing, meaning to say email, service, and the like, okay, pleadings and other documents must be served or filed personally or by registered mail when allowed, and shall not be served or filed electronically unless express permission is granted by the court. Initiatory pleadings and initial responsive pleadings, such as answer, you still have to file it, what you call this, personal or by registered mail. Subpoena protection orders like your TPO, okay, and the writs, WPI, writ of preliminary attachment, and appendices and exhibits to motions or other documents that are not readily amenable to electronic scanning may, at the option of the party filing such, be filed and served conventionally. And of course, sealed and confidential documents or records. Okay. Now, okay. Another thing is summons. Naku, dyan po, marami hong pagbabago po dyan sa summons. Okay? Now, summons can be served actually, okay, by whom served, the summons may be served by the sheriff or his deputy or proper court officer, and in case of service of summons by them, okay, failure of service of summons by them, the court may authorize the plaintiff to serve the summons together with the sheriff. In cases where summons is to be served outside the judicial region of the country where the case of the court where the case is pending, plaintiff shall be authorized to cause the service of summons. Now, if the plaintiff is a juridical entity, it shall notify the court in writing and name its authorized representative therein, attaching the board resolution or sex cert thereto as the case may be, stating that such representative is duly authorized to serve the summons on behalf of the plaintiff. And of course, pag nagsinungaling si plaintiff na sinerve niya, yung pala hindi niya sinerve, then the plaintiff shall be meted appropriate sanctions, and of course, that will include also the plaintiff's counsel, no? If he was the one who served the summons. Okay. Now, failure to comply with the order shall cause the dismissal of the initiatory pleading without prejudice if there's failure to serve the summons. Okay. Now, other provisions on summons, kumbaga marami yung pagbabago talaga sa Rule 8 at sa Rule 14. Now, service of spouse, upon spouses are sued jointly, service of summons should be made to each spouse individually. Hindi, kasi pag iniwan nyo sa lalaki lamang at nakademanda din yung babae, nag-personal service ka sa lalaki, nag-substituted service ka sa babae kasi iniwan mo dun sa asawa kaagad, hindi ka nakakomply dun sa Manotoc doctrine, no? So that will be improper service of summons insofar as the wife is concerned. Okay. Now, malaki ding pagbabago ko dito sa service upon domestic private juridical entity. So when the defendant is a corporation, partnership, or association organized under the laws of the Philippines with a juridical personality, service may be made on the president, managing partner, general manager, corporate secretary, treasurer, or in-house counsel of the corporation, wherever they may be found, which means even in, let's say, in a sports club, no, or in their house, or in their absence or unavailability, their secretaries. But please take note, if the service cannot be made upon the foregoing persons, the corporate officers or the secretaries, it shall be made upon the person who customarily receives the correspondence for the defendant at its principal office. Now, in case a domestic juridical entity is under receivership or liquidation, serve it to the receiver or the liquidator as the case may be. Should there be refusal on the part of the above person's name, so the corporate officers, their secretaries, and then the persons authorized to receive the correspondence customarily, okay? And despite at least 3 attempts on 2 different dates, service now may be allowed electronically if allowed by the court. So which means you have to file a motion first, okay? You have to narrate all the factual antecedents and then ask the court to allow you to serve the summons electronically. Okay. Now, okay, let me just skip some so that because I have a number of cases that I will have to discuss with you. Okay, I just would like you to focus on voluntary appearance. The defendant's voluntary appearance in the action shall be equivalent to service of summons. Yan, okay yan. Alam natin lahat yan. Pero ito yung katanungan ko, the inclusion in a motion to dismiss of other grounds, aside from lack of jurisdiction over the person of the defendant, shall be deemed voluntary appearance. My question here is this: you cannot include in a motion to dismiss lack of jurisdiction over the person of the defendant. Why? Because it should be raised based on Section 12 of Rule 8 as a ground, as affirmative defense in your answer. Kaya parang, nung binabasa ko to, parang somewhere I got lost too, no? Because you cannot file a motion to dismiss on the ground of lack of jurisdiction over the person of the defendant. And then secondly, if you did, but let's say you raise improper venue, ano na yun? Considered as voluntary submission. Because why? Because you included grounds other than lack of jurisdiction over the person of the defendant. So my suggestion is, as far as lack of jurisdiction over the defendant is concerned, just raise it as raise it as an affirmative defense in your answer. Okay. Now, ito ho yung prohibited pleadings, but let me just discuss certain things, no? Okay. Ang motion to dismiss, okay, will be based on lack of jurisdiction over the subject matter, litis pendentia, res judicata, statute of limitations. So yung 4 na yan, pwede niyong erase as an affirmative defense. Pero pwede kayo mag-file ng motion to dismiss kasi motion to dismiss prohibited except on the following grounds. Hindi po siya 3 kasi itong pangatlo nakalagay or by statute of limitations. Sana binaba para hindi nalito. No? Motion to hear affirmative defenses, hindi na ho tayo magpa-file ho niyan. Motion for recon, okay, this is another thing that I would like clarity on later on siguro, okay? Because if you will read Rule 8, Section 12, di ba ang sabi ho natin, pag yung affirmative defenses ay denied, hindi kayo pwede mag-file ng motion for recon, hindi kayo pwedeng i-certiorari yan, prohibition, hindi pwede. So, ang thinking natin, pag denied. Pero pag binasa ho natin yung Section 12, okay, C, motion for recon of the court's action on the affirmative defenses, which means it will even include a motion for recon if the affirmative defense has been granted by the court. Hindi ka pwedeng mag-MR. Yun, napaka-importante po nun. Kasi kung granted yan, okay, di ibig sabihin yan, final order yan, so dapat yan, ang remedy mo dyan, depende kung appeal o depende kung pwede kung dismiss without prejudice, di ba? Dapat ang remedy mo dyan is you either refile or you file a Rule 65 petition because you cannot appeal a judgment that was dismissed, okay? Calling for the dismissal of the complaint without prejudice. Now, kung nag-file ka ng motion for recon, prohibited pleading yan on the court's action on the affirmative defense. Pag nag-file ka dahil prohibited pleading yan, technically, it will not stop the running of the period because you filed a prohibited pleading. Okay? Now, okay. And then, of course, you have motions now that are litigious and non-litigious. Okay. And all motions shall be served by personal service, accredited private courier, or registered mail or electronic. Okay. The opposing party shall file his or her opposition to a litigious motion within 5 calendar days from receipt thereof. Okay. Ano po yung importante ho dyan? Di ba tinanggal na natin yung notice of hearing? Wala na yung 3-day notice rule. So the court may, in its discretion, if this is a litigious hearing, set it for hearing or not set it for hearing. Now, ang gusto mo, madinig ka on the litigious motion kasi nga litigious siya. You don't have to even wait for the court, okay, to issue an order requiring you to file an opposition because in the rules, the opposing party precisely has been given a period of 5 calendar days from receipt of the motion within which to file the opposition. And you cannot even ask for an extension of time anymore because under the rules of prohibited pleading, bawal humingi ng extension of time except if the motion for extension of time is a motion for extension of time to file an answer. Okay? Okay. Now. Okay. Here. Okay. This is Rule 18, no? And marami tayong pwede pag-usapan sa Rule 18, but let me just focus on Section 10 because of period of time lang, no? Okay. During the pre-trial, the court on its own, okay, can say, okay, I'll submit this case for judgment on the pleadings. Or on its own, can now submit it for summary judgment, okay, without need of position papers or memoranda. Okay. Now, pag sinabi ng court, I will submit this case on the basis of judgment on the pleadings or submit it on the basis of summary judgment, that order submitting the case for judgment on the pleadings, okay, or summary judgment shall not be subject to appeal or certiorari. What does that mean? Hindi pa naman kasi yun yung judgment. Sinasabi lang ng order na court na isasubmit ko to for decision on the basis of judgment on the pleadings or summary judgment. And therefore, that order is not actually the final order yet. Kaya hindi talaga siya pwedeng appeal. Ngayon yung certiorari, it's within the discretion of the court. Okay. So what do? You just wait for the judgment, and if you get an adverse judgment, my suggestion is you now include that as one of the errors you will assign in your appeal. The fact that the judge, okay, submitted the case for judgment on the pleadings or summary judgment. Okay? Okay. Now, Rule 34, Section 2. Okay, Rule 34, Section 2. And this is a motion for judgment on the pleadings. Now, the court may motu proprio or on motion render judgment on the pleadings if it is apparent that the answer fails to tender an issue. Okay. Any action of the court on a motion for judgment on the pleading. If I file a motion for judgment of the pleading and it's granted, that order is not subject of an appeal or petition for certiorari, prohibition, or mandamus. Same rule applies when you talk about the action of the court on the motion for summary judgment. Okay. Now. Okay. Maybe I think let's have a 5-minute break first. Okay. Let's have a 5-minute break so that you'll get your wits back. And I will start now with the cases. So can we have a 5-minute break, please?
Yeah, and while taking a short break, I would just like to acknowledge those who commented their schools. A lot of people are showing their school spirit this afternoon, and we have viewers from University of Cordilleras by Xi'an. Your name is Xi'an. We also have viewers from UST Legazpi. Also watching from University of Eastern Philippines College of Law, Miss Joy Navales. Another viewer from Philippine Christian University, Mr. Joshua Marie Atienza Jarajeño. Another from University of Mindanao, this time from Davao City, Miss Lee Rap Perez. Hello daw po, Dean Festin from Miss Judith Francisco. Also a comment from Mr. J. Coruña, watching our dearest Dean Sol Nawis, probably from Lyceum University. Yeah, and we also have watching from Rizal Memorial College's School of Law, Davao City, Miss Janet Saniel. Another comment from Miss Cora Esther Munisit. Good afternoon, Dean, watching here in Cebu. Thank you. So for our viewers, you can also post your comments or questions in the comment section, and our lecturer will answer later on. Thank you, and please stay with us until the end.
Okay. Okay, I'm sorry. We cannot take a longer than a 5-minute break, so I will have to continue. Okay, so let me now go back to the cases, no, that more or less, okay, will not be, the ruling has not been affected by the 2019 amendments. Okay, now let me first discuss a case of Bello versus Marcantonio. Okay, Bello filed a complaint for foreclosure of mortgage against Marcantonio. For the sheriff's return, copies of said summons and the complaint, along with its annexes, were left to a certain Giovanni Marcantonio, the alleged respondent's niece, no? Because respondent was not at home at the given time when the summons was served. No responsive pleading was filed. Thus, upon petitioner's motion, respondent was declared in default. Petitioner was then allowed to present evidence ex parte, and thereafter the case was submitted for decision. Okay. Before judgment, however, was rendered, respondent learned about petitioner's case against her, so the respondent immediately filed a motion to set aside lift order of default and to reopen the trial on the ground of defective service of summons. The RTC denied the motion and held that the substituted service of summons upon respondent was validly made. Okay. So Mercan Antonio, after filing, of course, a motion for reconsideration, which was denied, filed a Rule 65 petition with the Court of Appeals. The CA ruled that there was indeed improper resort to substituted service of summons, as there was only a single attempt to affect personal service. So ni-reverse niya yung ruling ng RTC. On the matter of voluntary submission to the jurisdiction of the CA, of the court, the CA ruled that the respondent's motions cannot be deemed as voluntary appearance that vested jurisdiction upon the trial court over the person of the respondent, considering that they were filed precisely to question the court's jurisdiction. So the issue in this case is whether the respondent may be granted relief from the RTC's default order. In the case of Manotoc versus Court of Appeals, which by the way has already been codified, no? Nakapasok yung ruling ni Manotoc versus CA sa ating 2019 Rules on Civil Procedure. The court ruled that before the sheriff may resort to substituted service, he must first establish the impossibility of prompt personal service. To do so, there must be at least 3 best effort attempts, preferably on at least 2 different dates, to effect personal service within a reasonable period of 1 month or eventually result in failure. It is further required for the sheriff to cite why such efforts were unsuccessful. It is only when the impossibility of service can be confirmed or accepted that you can now resort to substituted service of summons. Now, the Supreme Court said, as correctly found out by the Court of Appeals, the sheriff, in fact, made only 1 attempt to personally serve summons. Further, he in his sheriff's report, there was only a general statement as to the earnest efforts he expended. No? Clearly, this does not suffice according to the Supreme Court. The Supreme Court also observed that the sheriff even committed a mistake when the identity of the person who received the motion was he mistakenly identified it as the person as the niece, when in truth and in fact daughter pala siya nung defendant. Okay. So sabi ng Supreme Court, talagang hindi nagawa ng sheriff yung dapat niyang gawin. Okay. The fact that a defendant has lost standing in court for having been declared in default does not mean that he or she is left without any recourse to defend his or her case. The following are the remedies available to a party who has been declared in default. Okay. The defendant in default may at any time from the discovery thereof of the judge of the order declaring him in default, but before judgment, file a motion under oath to set aside the order of default on the ground that his failure to file an answer was due to fraud, accident, mistake, or excusable neglect. And of course, he must have meritorious defense. Okay. Number 2, if there's a judgment already, okay, if there's a judgment already, but before the same had attained finality, then the remedies will be 3: appeal, MR, MNT. Now, if the defendant discovered the default after the judgment has already attained finality, then of course you have your Rule 38, Section 2. Okay, now, in this particular case, the Supreme Court said it is important to emphasize that the fact of improper service of summons in this case was never disputed, was in fact established. Despite such meritorious justification to failure to file an answer, the trial court insisted on the validity of the default order and continuously disallowed the respondent to participate in the proceedings and defend her case. Such improper service of summons rendered the subsequent proceedings before the trial court null and void, as it deprived the defendant her right to due process. Okay. Tirol versus Nolasco. Okay. Spouses Gloria and Roberto died intestate. Okay. They were survived by their 6 children. Okay. Ruth, Cecilia, Marilu, Seriaco, Ana, and Roberto Jr. Roberto Jr., one of the children, died intestate and was survived by his own 4 children, Martin, Zarina, Francis, and Daniel. At the time of his death, Roberto Jr.'s first marriage with his first wife, okay, had been annulled. Now, petitioner Martin, Cecilia, and Seriaco filed a petition to probate the wills of their grandparents, Gloria and Roberto Sr. Ruth and Mary Lou later joined as interveners. And that was before RTC Branch 128. Okay. And RTC Branch 128 admitted to probate the respective wills of their grandparents and designated Martin as the administrator of their estate. So tandaan natin, may isang korte, RTC 128. Doon nakafile yung probate ng wills of their grandparents. Meanwhile, okay, there is this respondent Sol, okay? Who turned out to be the second wife, okay, of Roberto Jr., okay? She filed now a motion for intervention in the intestate settlement of Roberto's Jr. estate proceedings. So you have two cases, one pending before RTC 128, yun po yung estate proceedings, testate estate proceedings ng grandparents. Meron pang isa sa Branch RTC 101, yun naman yung intestate estate proceedings of Roberto Jr. Now, RTC 218, the court that is hearing the wills of the grandparents, denied the motion to intervene filed by respondent Sol as stating that she has no legal interest in the case. Because she also filed a motion to intervene there in the probate in RTC 128, okay, saying that I am the legal wife of one of the heirs there, and because the heir died, I have now to intervene because I have an interest to protect. Now, because of the denial, she went up to the CA on a petition for certiorari. Okay. The CA found respondent Sol's certiorari petition to be meritorious. The CA stated that respondent Sol should be allowed to intervene because she is the widow of Roberto Jr. and has an interest or claim in her husband's estate, which consists in part of the latter's share in the estate of the deceased mother, Gloria, and the extent or value of the share of Roberto Jr. has not yet been determined. So what is the issue in this case? Whether or not the CA erred in not giving due consideration that respondent Sol's intervention will undo 14 years worth of resolved incident. No? In fact, okay, now, in this case, the petition according to the case to the Supreme Court is meritorious. Now, given the existence of the settlement of Roberto Jr.'s estate proceeding, the question has to be resolved in the negative. In the settlement of a deceased estate, Section 1, Rule 73 of the Rules of Court provides the court first taking cognizance of the settlement of the estate of a decedent shall exercise jurisdiction to the exclusion of other courts. Given the exclusivity of the jurisdiction granted to the court first taking cognizance of the settlement of decedent's estate, RTC 101 has the exclusive jurisdiction over the intestate estate of Roberto, while RTC 218 has exclusive jurisdiction over the estates of Gloria and Roberto Sr. Thus, only RTC 101, the court where the settlement of Roberto Jr.'s estate proceeding is pending, has the jurisdiction to determine who are the heirs of Roberto Jr. Okay. The court which has jurisdiction to hear and decide any controversy as to who are the lawful heirs of Roberto Jr. or as to the distributive shares to which each is entitled to receive under the law is RTC 101. Okay. Because it is the court which has first taken cognizance of the settlement of the intestate estate of Roberto Jr. RTC 218, where the probate proceeding is pending of probate proceedings of the will of the grandparents, cannot rule on who are the heirs of Roberto Jr., even if the share of Roberto Jr. in the estate of his parents is to be determined therein. The probate court must yield to the determination by Roberto Jr.'s estate settlement court of the latter's heirs. This is to avoid confusing and conflicting dispositions of a decedent's estate by co-equal courts. Now, As to the protection and preservation of the share of Roberto's Jr. share in the testate estate of his parents, the same will have to be undertaken, okay, and looked at by the administrator or executor as appointed. Okay. Now, moreover, and now we focus on the intervention. The intervention of Respondent Sol in the probate proceeding, in fact, will be superfluous because she has an available remedy in the settlement of Roberto Jr.'s estate proceeding to question any action of the administrator therein which is detrimental to the estate. Since intervention is not a matter of right, but depends on the sound discretion of the court, Respondent Sol's intervention in the probate proceeding of Roberto Jr.'s parents is unnecessary because her right or interest in the estate of Roberto Jr. can be fully protected in a separate proceeding which is pending before RTC 101. Okay. So the second parameter to be considered in granting of intervention under Section 1, Rule 19, even as amended, whether the intervener's right may not be fully protected in a separate proceeding, is wanting in the instant case. And in fact, there's another reason why the motion for intervention should be denied. Okay? Why? Because it will introduce an independent controversy. Okay? The issue as to whether or not Respondent Sol is a lawful heir of Roberto Jr., because the children were saying the second wife now is not really the wife because the wife, the marriage of the second wife to their deceased father is bigamous. Because at the time they married, Respondent Sol had a valid and subsisting marriage. So the issue as to whether Respondent Sol is a lawful heir of their deceased father will definitely enlarge the issues in the probate proceedings involving the testate estate of their grandparents and would involve determination of facts peculiar only to her, which have nothing to do with the original parties. The other heirs of Gloria and Roberto Sr. are not interested as to who are the lawful heirs of Roberto. The respective shares of such other heirs in the estates of Gloria and Roberto will in no way be affected by who are declared as the lawful heirs of Roberto Jr. in the proceeding for the settlement of his estate. Because of this extraneous issue, being injected in the probate proceeding, the first parameter has to be considered whether to allow an intervention under Section 1 or Rule 19. No undue delay or prejudice in the adjudication of the rights of the original parties is not met. Thus, the intervention should be denied. Okay? The intervention of Respondent Sol in the probate proceedings of the grandparents of her deceased husband. Okay. Now, in the case of City of Makati versus Municipality of Bakun, okay, just give me a minute, please. Okay. The case sprang from a special civil action for interpleader under Rule 62 with a prayer for WPI and TRO. Okay. Luzon Hydrocorp, okay, sought to compel the City of Makati, the Municipality of Alilem, and the Municipality of Bakun, so tatlong munisipyo yan, dalawang munisipyo, isang city, to litigate amongst themselves their conflicting claim on Luzon's liability for local business tax under RA 7160. The petition for interpleader was given due course. Defendants municipalities Alilem and Bakun, as well as the City of Makati, were all declared to be entitled to the 70% business tax collection of the plaintiff to be distributed starting the taxable year. Now, this decision, only the municipality of Bakun appealed to the CTA. The CTA modified the ruling of the RTC and ruled that only the municipalities of Bakun and Alilem are hereby declared the only government units entitled to equally share in the 70% allocation made by Luzon for the payment of its local business tax. So Makati now filed, okay, a petition for review before the CTA and bank. So the CTA, whether or not the CTA and bank and its special first division erred in ruling in favor of the municipality of Alilem, which did not appeal before the CTA. I'm just focusing in this particular case on the procedure. Okay. Ang nag-apili lamang ay si Municipality of Bakun, but the decision rendered by the CTA, okay, favored also Municipality of Alilem, that municipality that did not appeal. Okay. Sabi ng Supreme Court, only Bakun, okay, it is not wrong, okay, it is not wrong to have to, for the city of Alilem, okay, to enjoy the benefits of the favorable judgment obtained by the municipality of Bakun. Bakun and Alilem share a commonality of interest in the case. The fact that only Bakun appealed from the RTC's decision in the interpleader case does not preclude Alilem from benefiting in a judgment favoring Bakun. The site of Luzon's hydroelectric power plant straddles both Alilem and Bakun, and the controversy involved the same question of law. Okay. What is the general rule? Indeed, one party's appeal from a judgment will not inure to the benefit of a co-party who failed to appeal. And as against the latter, the judgment will continue to run its course until it becomes final and executory. That is the general rule. But there is an exception to the general rule, and the exception applied in this case, which is where both parties have a commonality of interest, the appeal of one is deemed to be the vicarious appeal of the other, and therefore the one who appealed and obtained a favorable decision, it will inure to the benefit of the non-appealing party. Okay. Now, let me now discuss the case of in the matter of declaratory relief on the validity of BIR revenue memorandum, okay, circular clarifying the taxability of association dues. Okay. Again, I will just focus on the procedural aspect of the case. The First E-Bank filed a petition for declaratory relief seeking to declare as invalid RMC number 65/2012, clarifying the taxability of association dues, membership fees, and other assessments. The RTC ruled that the First E-Bank correctly resorted to a petition for declaratory relief for the purpose of invalidating RMC number 65/2012. It also declared as invalid RMC 65/2012 for it purportedly expanded the law, creating an additional tax burden on condominium corporations, and was issued without the requisite notice or hearing. Okay. The CA dismissed the appeal of the First E-Bank and the joint appeal of the BIR on the ground of lack of jurisdiction. It emphasized that jurisdiction over the case was exclusively vested with the CTA since the trial court's impugned resolution involved a tax matter. Both the First E-Bank and the BIR moved for recon. They commonly asserted that the CA had appellate jurisdiction over the respective appeals emanating from a petition for declaratory relief, okay, which sought to invalidate RMC number 65/2012. Okay. So the issue in this case is a petition for declaratory relief proper for the purpose of invalidating RMC number 65/2012. Okay. Is not the proper remedy according to the Supreme Court. The petition for declaratory relief is not the proper remedy. Why? One of the requisites for an action for declaratory relief is that it must be filed before any breach or violation of an obligation. Thus, there is no actual case involved in a petition for declaratory relief. It cannot, therefore, be the proper vehicle to invoke judicial review powers to declare a statute unconstitutional. It is elementary that before the court can rule on a constitutional issue, there must be first a justiciable controversy. A justiciable controversy refers to an existing case or controversy that is appropriate or ripe for judicial determination, not one that is conjectural or merely anticipatory. To question the constitutionality of the subject issuances, respondents should have invoked the expanded certiorari jurisdiction under Section 1 of Article 8 of the 1987 Constitution. The adverted section defines judicial power as the power not only to settle actual controversies involving rights which are legally demandable and enforceable, but also to determine whether or not there has been a grave abuse of discretion amounting to lack or in excess of jurisdiction on the part of any branch or instrumentality of the government. Now, there is grave abuse of discretion when there is patent violation of the Constitution, the law, or existing jurisprudence. On this score, it has been ruled that the remedies of certiorari prohibition are necessarily broader in scope and in reach, and the writ of certiorari of prohibition may be issued to correct errors of jurisdiction committed not only by a tribunal, corporation, board, or officer exercising judicial or quasi-judicial power. Okay? It also can be used against the government even if the latter does not exercise judicial, quasi-judicial, or ministerial functions. Thus, petitions for certiorari and prohibition are the proper remedies where the action of the legislative branch is seriously alleged to have infringed the Constitution. Okay. The court nevertheless held that a petition for declaratory relief may be treated as one for prohibition if the case has far-reaching implications. So even if sinabi ng Supreme Court sa kaso na to na petition for declaratory relief is not the proper remedy, it treated this case as a petition for prohibition. Okay? Okay, because of its far-reaching consequence. Okay. Now, Zomer Development versus Special 20th Division of the CA. Zomer Development filed a complaint for declaration of nullity of notice of sale, certificate of sale, TCT, and declaration as unconstitutional. Zomer wanted to declare Section 47 of RA 8791 or the General Banking Law of 2002 to be unconstitutional. Why? Because it violates its right to equal protection since the law provides a shorter period of redemption of 3 months or earlier to juridical entities compared to 1 year redemption period given to natural persons. This discrimination, Zomer argued, gives undue advantage to lenders who are non-banks. So copies of the complaint were furnished to the Office of the Solicitor General. But the Office of Solgen did not participate in the case. Be that as it may, the RTC dismissed the complaint. The trial court refused to rule on the constitutionality of RA 8791, Section 427. According to the trial court, to rule on the issue will deprive the Republic of its right to due process since it was not heard on the issue and was not pleaded as party defendant in this case. Okay. They then went up, Zomer went up on appeal. No? The CA dismissed the appeal without prejudice to appellants filing the appropriate case before the Supreme Court. The CA categorized Zomer as one for declaratory relief, and again, CA refused to make a definitive ruling on the constitutionality issue, citing Rule 63 of Section 5 of the Rules of Courts on the discretion of courts to entertain petitions for declaratory relief. The CA, in fact, held that the case is novel and can be best resolved by the Supreme Court. Okay. Now, so petitioner filed a mandamus. Ayaw i-rule ng RTC, ayaw i-rule ng CA. So anong ginawa niya? Nag-file siya ng petition for mandamus before the SC. It argued that mandamus was the proper remedy because the CA evaded its duty to decide on the constitutionality of RA 8791, Section 47. It adds that in declining to rule on the issue, the CA deprived it of its right to due process since it did not put an end to the controversy between the parties. So the issue here is whether or not the petition for mandamus, okay, was the proper remedy, or whether the CA can be compelled to rule on the constitutionality of a statute by writ of mandamus. Anong sabi ng Supreme Court? The answer is no. Okay. The complaint, while denominated as a declaration of nullity of notice of sale, certificate of sale, and TCTs, and declaration as unconstitutional Section 47 of RA 8791, was in reality a petition or an action for a complaint for declaratory relief. Okay? Why? Because petitioner, in seeking the nullification of the foreclosure sale, questioned the validity of the law insofar as it limits the redemption period for juridical persons to only 3 months. Petitioner was a juridical person affected by the shorter redemption period. Hence, under Article 63, Section 1 of the Rules of Court, any person whose rights are affected by a statute may bring an action before the trial court to determine its validity. The grant of declaratory relief is discretionary on the courts. Courts may refuse to declare rights or to construe instruments if it will not terminate the controversy or if it is unnecessary and improper under the circumstances. A discretionary act cannot be a subject of mandamus. Declaratory relief is discretionary upon the court to entertain. It may refuse to exercise the power to declare rights and to construe instruments in any case where the declaration or construction is not necessary and proper at the time under all circumstances. So you cannot compel, the RTC and the CA to rule on the constitutionality if what was filed before them is, like, for example, in the RTC it's a petition for declaratory relief. Okay. Although the RTCs have exclusive original jurisdiction over actions for declaratory relief, the CA exercises appellate jurisdiction over final judgments of the trial court. Thus, the CA may, in appeals of action for declaratory relief, apply Rule 63 of the Rules of Court in resolving the appeal. And the CA, in deferring the question of the validity of RA 8791, Section 47, and held to resolve the petition, would be an empty discourse and will not terminate the controversy. This was an exercise of the CA's discretion. Petitioner, therefore, cannot file a petition for mandamus to compel what is essentially a discretionary act on the CA. What petitioner should have done, and this is what, according to the Supreme Court, is the proper remedy, was to file a petition for certiorari to question the exercise of the CA's discretion. Unfortunately, petitioner filed the wrong remedy. Ang ginawa niya, nag-Rule 45 siya. As such, the petition must be denied. Okay. Another 2020 case. Okay. Madera versus CO, Commission on Audit. Okay. Now, in this case, the Supreme Court said the court notes that the petition was filed out of time. Kasi the COA decision, COA decision, inakyat niya via Rule 64. Okay. But the petitioners confused Rule 64 and 65 of the Rules of Court when they erroneously claim that their Rule 64 petition was timely filed within 60 days from notice of judgment. Rule 64 provides, this rule shall govern the review of judgments and final orders and resolutions of the COMELEC or COA. Mode of review, a judgment or final order or resolution of the Commission on Elections and the Commission on Audit may be brought by the aggrieved party to the Supreme Court on certiorari under Rule 65, except as hereinafter provided. Time to file. The petition shall be filed within 30 days. From notice of the judgment or final order or resolution sought to be reviewed, the filing of a motion for new trial or recon, if allowed under the rules of those bodies, shall interrupt the running of the period. If the motion be denied, the aggrieved period may file the petition within the remaining period, but which shall not be less than 5 days. Na-confuse siguro yung petitioner, kasi sabi, i-file daw under Rule 65. Yung 64, i-file daw under pursuant to Rule 65. Ang 65, 60 days for you to file a Rule 65 petition. So, kala niya, yung 64 petition, pwede niya i-file within 60 days from receipt of the judgment or of the denial of his motion for recall. But Section 3 is very clear. You have to file it, the Rule 64 petition, should be filed within 30 days from notice of the judgment or final order or resolution sought to be reviewed. Now, if you file the motion for reconsideration, you have the remaining balance of the period within which to file your Rule 64 petition, but in no case less than, 5 days. So as can be gleaned, Rule 65 applies to petitions questioning the judgments, final orders, or resolutions of COA only insofar as Rule 64 does not specifically provide the rules. Consequently, since Rule 64 explicitly provides the 30-day period for the filing of the petition, the same shall apply, not the 60-day period provided under Rule 65. Okay. Now, Yokohama Tires versus Reyes. Okay. Petitioner filed a criminal complaint for qualified theft against respondents and Tagudin, accusing them of having taken HP ink cartridges from the company's stockroom through stealth and without the consent of petitioner or any of its authorized representatives. The ACP, of Angeles City recommended that the complaint against Tagudin be dismissed for insufficiency of evidence, while an information for attempted theft be filed against the respondents. An information for attempted theft was then filed before the MTC of Pampanga. Thereafter, trial proceeded. Hence, on November 10, the MTC Clark Pampanga rendered its decision acquitting the respondents of the crime of attempted theft. Petitioner then filed a petition for certiorari with the RTC, contending that MTC acted without or in excess of jurisdiction and or grave abuse of discretion in ruling that the pieces of HP ink cartridges found by the petitioner's representatives inside the vehicle of one of the respondents, which was subsequently presented as evidence by the prosecution, were inadmissible for having been obtained in violation of the law and respondents' right against unreasonable searches and seizures. So petitioner prayed for the annulment of the MTC decision before the RTC. Now, the RTC dismissed the petition for certiorari for lack of merit. MR denied. Yokohama went straight to the Supreme Court on Rule 45. Okay. So according to the Supreme Court, the petitioner, Yokohama, lacked the authority in filing a special civil action for certiorari with the RTC to seek the annulment of the decision of the MTC, which acquitted the respondents for the crime of qualified theft. Why? Because in criminal cases, the state is the offended party and the private complainant's interest is limited, to the civil liability, arising therefrom. Hence, if a criminal case is dismissed by the trial court or if there is an acquittal, a reconsideration of the order of dismissal or acquittal may be undertaken whenever legally feasible. Insofar as the criminal aspect thereof is concerned, it may be made only by the public prosecutor or in the case of an appeal by the state only through the office of the Solicitor General. The private complainant or offended party may not undertake such motion for recon or appeal on the criminal aspect of the case. However, the offended party or private complainant may file a motion for recon of such denial or acquittal or appeal therefrom, but only insofar as the civil aspect thereof is concerned. So hindi real party, hindi proper party yung private complainant to file the Rule 65 petition because precisely what is being appealed is the decision, on the criminal aspect of the case. The rationale behind this rule is that in a criminal case, the party affected by the dismissal of the criminal action is the state and not the private complainant. The interest of the private complainant or the private offended party is limited only to the civil liability. In the prosecution of the offense, the complainant's role is limited to that of a witness. The complainant's role is limited to that of a witness for the prosecution, such that when a criminal case is dismissed by the trial court or if there is an acquittal, an appeal therefrom on the criminal aspect may be undertaken only by the state through the Solgen. The private offended party or complainant may not take such appeal, but may only do so as to the civil aspect of the case. Okay. Spouses Liu versus Court of Appeals. Okay. Okay. In the complaint, petitioners allege that they are the registered owners of a parcel of land with the assessed value of 90,000 pesos plus and a market value of 99,000 pesos plus. They discovered that their original owner's duplicate copy of the TCT was missing. Hence, they reported the loss to the police authorities. Petitioners further alleged that they executed an affidavit of loss and caused its annotation at the dorsal portion of the original certificate of title. They also discovered that 2 entries were also annotated at the dorsal portion of the original title, to wit, a sham affidavit of recovery and a spurious special power of attorney. They also discovered an annotation with no entry number referring to an absolute deed of absolute sale between private respondent and Tech Ling Yao, showing that petitioner's subject property was sold to private respondents. Okay. Private respondent denied the allegations of the petitioners, and as an affirmative defense, he basically averred that he was a buyer in good faith, na hindi niya alam na yan ang mga pangyayari. So during the trial, when it was private respondent's turn to present evidence, he filed a motion to dismiss on the ground of lack of jurisdiction considering the assessed value of the subject property. Okay. The RTC denied the motion to dismiss. The CA affirmed the decision of the RTC. After the MR was denied, the petition was filed. The petition filed under Rule 65 petition before the Supreme Court. Okay, in the first place, the instant petition for certiorari is a wrong remedy and must therefore fail. The petition should not have been given due course at all. Well settled is the rule that appeals from judgment or final orders or resolutions of the CA should be by a verified petition for review on certiorari under Rule 45 of the Rules of Court. The court made it clear that an aggrieved party is prohibited from assailing a decision or final order of the CA via Rule 65. It should be really Rule 45. Because this recourse is proper only if the party has no plain, speedy, and adequate remedy in the course of law. In this case, petitioner had an adequate remedy, which is appeal, a petition for review on certiorari under Rule 45. Therefore, a petition for review on certiorari under 45 is the correct remedy and not a special civil action for certiorari under 65. Okay. Now, okay. Remember that 65, Rule 65, is different from Rule 45. Ang Rule 65 is to correct errors of jurisdiction. Ang Rule 45 is actually what? It's based on pure question of law. And it is part of the appeals process, which means the subject matter of a Rule 45 petition is a final judgment or a final order. Whereas a general rule, Rule 65, it's usually directed against an interlocutory order. In Rule 45 and 65, they are mutually exclusive. Okay, they are not one after the other. They are mutually exclusive. So one must not confuse and one must know, therefore, when to avail of 65 or 45. Okay. Now, this is not a 2020 case, but I think it's best for us to just recall basically the teachings, okay, in the case of Republic versus Sereno. Now, in Republic versus Sereno, I remember that was one issue there that saying that the Solicitor General does not have the authority to file the petition. Okay? He has to be instructed by the President. Well, according to the case of Republic versus Sereno, that argument is wrong. The Solicitor General, in the exercise of sound discretion, may suspend or turn down the institution of an action for quo warranto where there are just and valid reasons. Upon receipt of a case certified to him, the Solgen may start the prosecution of the case by filing an appropriate action in court, or he may choose not to file the case at all. The Solgen is given permissible latitude within his legal authority in actions for quo warranto circumscribed only by the national interest and the government policy on the matter at hand. He is given the wide latitude to determine whether he should file the case or not, with or without the president's directive. Second takeaway, in the case of Sereno, the Supreme Court held that the inaction of a person claiming right over a public office to assert the same within the prescriptive period provided by the rules may be considered a waiver of such right. This is where the difference between quo warranto filed by a private individual as opposed to one filed by the state through the sole gen. There is no claim of right over a public office where it is the state through the sole gen which files a petition for quo warranto to question the eligibility of the person holding the public office, while a private individual may be deemed to have waived his right over title to a public office and or to have acquiesced or consented to the loss of such right. The same cannot be said when the state, by mere lapse of time, failed to contest such. The state cannot be faulted and cannot be said to have waived its right by mere lapse of time to uphold and ensure compliance with the requirements of such office fixed by no less than the Constitution. So this 1 year period stated with respect to the filing of quo warranto petition, does not apply to the state. It would be therefore absurd to require the filing of a petition for quo warranto within the 1 year period when it is the state itself which files the same, or not for the purpose of determining who among two private individuals are entitled to the office. While the purpose of the instant petition is not to inform the government that it is facing a predicament of having to pay two salaries, rather than the government having learned of a predicament that it might be paying an unqualified person and it's only acting as such. So when the government is the real party in interest, there can be no defense on the ground of laches or limitation. Prescription does not lie against the state, especially when the action concerns public interest. The court clarified that it is not abolishing the limitations set by the rules in instituting a petition for quo warranto. The 1 year prescriptive period under Section 11, Rule 66 still stands. However, when such petition is filed by the state at its own instance through the Solicitor General, prescription shall not apply, which means, therefore, that the 1 year period will apply if the petition is filed by a private individual in his own name. Then the prescriptive period will apply. Esperal versus Esperal. Petitioner was surprised that her property, which was a vacant lot when she left for the United States, was now occupied by persons unknown to her. Upon inquiry, the occupants informed her that they were lessees and paying rentals to Biaco, nephew of Trumpeta. She then told the occupants that she's the owner of the property and that she did not authorize Biaco to have the property leased to anyone. When the petitioner returned to the property, she met Biaco. The latter confirmed that he managed the property and collected rentals for his aunt Trumpeta. Petitioner told him that she is the owner of the property and not his aunt. Upon hearing this, respondents voluntarily left the premises. Thereafter, petitioner took over the possession of the property and designated her sister, Rosario, to be the property administrator. She likewise made an arrangement with the lessees to pay the rentals to Rosario. Thus, she changed the locks of the gate of the subject property. For more than 2 weeks, everything was peaceful. On the third week, however, when petitioner was back in the U.S., Ola informed her that their tenants were not allowed to enter the subject property, that respondents entered the premises by destroying the locks using a bolt cutter, and that respondent changed the locks, prohibited the tenants from entering the premises, and posted a rent signage. Petitioner's counsel then sent a demand letter to the respondents for them to vacate the subject property. Despite the receipt of the demand letter, the respondents refused to leave the subject property, prompting petitioner to file the complaint for ejectment and damages against respondents before the METC. For their part, respondents averred that complaints should be dismissed outright, as petitioner is not the real party in interest because she was not the owner of the subject property. METSI ruled in favor of the petitioners. RTC affirmed the decision of METSI. CA, however, reversed the decision of the RTC. The Court of Appeals erred in holding that an ejectment case is not proper due to the contrasting claims of ownership by both petitioner and the respondent. Now, whether the court can resolve an ejectment suit even if both parties claim ownership over the said property, according to the Supreme Court. Enforceable entry and unlawful detainer cases, even if the defendant raises the question of ownership in his pleadings and the question of possession cannot be resolved without deciding the issue of ownership, the lower courts, the Court of Appeals, nonetheless, have the undoubted competence to provisionally resolve the issue of ownership for the sole purpose of determining the issue of possession. Such decision, however, does not bind the title or affect the ownership of land, nor is conclusive of the facts therein found in a case between the same parties upon a different cause of action involving possession. Moreover, the court emphasized that the issue of ownership shall be resolved in deciding the issue of possession only if the issue of possession cannot be resolved without resolving the issue of ownership. Okay. Now, oops. Okay, here. Let me just delete this because I'm going to leave this with you, no? Palagay ko na doble lang to. Just allow me to edit it a bit. Okay. Sumobra lang. Let me discuss the case of Britannia versus Honorable Gepti. Okay. Blas Britannia initiated an action for judicial foreclosure of mortgage against Panganiban. Okay. The trial court rendered its decision denying the complaint for judicial foreclosure, albeit granting Britannia's monetary claims. The rate of execution was only partially satisfied. Upon the finality of the aforesaid decision, okay, a corresponding writ of execution was issued after the same Britannia filed a motion to examine judgment debtor Panganiban. Why? Because the judgment was not satisfied. According to Britannia, the 120 square meter property was fraudulently transferred to Panganiban's sister and then to another person a few days after the trial court's decision was issued. Okay. The motion was set for hearing, during which Panganiban did not appear. For this reason, Britannia moved that Panganiban be cited in indirect contempt of court. Okay? The trial court ordered Panganiban to comment therein within 10 days from notice. So nag-file siya ng motion to cite Panganiban in indirect contempt. Panganiban stated in the main that the 120 square meter parcel of land was not included in the trial court's decision denying the complaint for judicial foreclosure. She had always observed the rules and never meddled in or interrupted its enforcement. Okay. Now, she also said the trial court denied Britannia's oral motion for indirect contempt and motion to examine Panganiban. The CA affirmed the RTC's decision. Okay. Whether or not Panganiban Nan's appearance, okay, is an utter disregard of the trial court's authority, thus a ground to cite Panganiban for indirect contempt. Okay. And this is where I will have to discuss, when you file a petition for a person to be decided in indirect contempt, number one, if it's coming from the court can issue an order, okay, requiring the respondent, okay, to explain in writing why he should not be cited in indirect contempt. Pero kung manggagaling sa party yung gusto niyang ma-cite yung person in indirect contempt, the proper remedy is not to file a motion in court to cite the other party in indirect contempt. The proper remedy is for the petitioner, okay, the party who wants to cite this other party in indirect contempt, to file a written petition, an initiatory action, okay, That is the way for you to do it. You have to file an initiatory petition to cite this person in indirect contempt. The court has no authority to rule on a motion to cite X person in indirect contempt. Okay? If the motion comes from one of the parties. Okay? The other party's remedy is to file a separate independent action to cite this person in indirect contempt. At pag na-raffle na yan sa ibang judge yan, pwede nyo nang ipakonsolidate. Okay, now, let me discuss just 2 cases on criminal procedure, which was actually all en banc decisions. The majority of the decisions I mentioned here are actually en banc decisions. No? Okay, now, the case of Malampad versus Honorable Dax Zenos. Okay. Zaira was charged with the violation of the dangerous drugs law. So Zaire proposed to plea bargain the charge of illegal sale of dangerous drugs to the lower offense of possession. Okay. On the other hand, the city prosecutor argued that they are bound by the DOJ circular, so they had no choice but to reject Zaire's plea bargaining. Okay. And insisting that any bargaining outside the DOJ circular is not acceptable. So while the prosecution agreed to the plea bargain of this one criminal case, okay, illegal possession of dangerous drugs and illegal possession of drug paraphernalia, okay, there was no agreement with respect to the third case of Zaire, which is illegal sale of dangerous drugs. And the RTC denied Zaire's motion to plea bargain and set the case for pre-trial. His motion reconsideration was denied too. Now, what did he do? He filed a petition for certiorari and prohibition before the Supreme Court. Zaire seeks to declare DOJ Circular Number 27 unconstitutional for being in contravention with OCA Circular Number 90/2018, denying his offer to plea bargain the charge against him for illegal sale of shabu, okay, to illegal possession. Presiding Judge Zenos acted according to him, okay, Presiding Judge Zenos acted without or in excess of jurisdiction or with grave abuse of discretion amounting to lack of jurisdiction when he disregarded the provision of OCA Circular Number 90/2018. Zaire argues that the provision in the OJ Circular Number 27 pertaining to plea bargaining under Section 5 of RA 9165 is unconstitutional as it repealed, altered, or modified the more favorable plea bargaining provision under OCA Circular Number 90/2018. Okay. Now, the Supreme Court said, okay, yung pagka hindi, he wanted to plea bargain, ayaw ng prosecutor. Sabi ng court, set na natin to for hearing. Grave of abuse of discretion ba yun? Okay. Anong sabi ng Supreme Court? A plea bargain requires mutual agreement of the parties and remains subject to the approval of the court. The acceptance of an offer to plead guilty to a lesser offense is not demandable by the accused as a matter of right, but is a matter addressed entirely to the sound discretion of the court. Kaya nga sabi sa Section 2, Rule 116, at arraignment, the accused with the consent of the offended party and the prosecutor may be allowed by the trial court to plead guilty to a lesser offense, which is necessarily included in the offense charge, etc., etc. The use of the word may signifies that the trial court has discretion whether to allow the accused to make a plea of guilty to a lesser offense. Moreover, plea bargaining requires the consent of the accused, the offended party, and the prosecutor. It is also essential that a lesser offense is necessarily included in the offense charge. So the Supreme Court found it proper to treat the refusal of the prosecution to adopt Zaire's plea bargain as a continuing objection. Presiding Judge Zenos did not act without or in excess of jurisdiction or with grave abuse of discretion amounting to lack or in excess of jurisdiction in not approving the plea bargain of Zaire. Okay? There was a continuing objection on the part of the prosecution. Because of this continuing objection, the parties failed to arrive at a mutually satisfactory disposition of the case. that may be submitted for the court's approval, and the RTC therefore correctly ordered the continuation of the proceedings because there was no mutual agreement to plea bargain. Okay. Okay. Just allow me to drink. Just allow me. Okay. In the case of People versus Pagal, okay, the accused here pleaded guilty to the charge of murder. Okay. So the RTC found the plea to be voluntary and with full understanding of its consequences. This is an en banc case, no? Okay. Thus, it directed the prosecution to present evidence to prove the guilt of the accused appellant and to determine the exact degree of his culpability in accordance with Section 3, Rule 116 of the 2000 Revised Rules on Criminal Procedure. Okay. None of the prosecution witnesses appeared and testified on the scheduled hearing, not one. Okay. Despite repeated subpoenas duly issued and received by them. Okay. The defense chose not to present any evidence in view of the prosecution's non-presentation. Both the prosecution and the defense moved for the submission of the case for decision. So what happened? The RTC found the accused guilty beyond reasonable doubt based solely on his plea of guilty. It stated that the accused appellant maintained his plea despite being apprised that he would be sentenced and imprisoned on the basis thereof. Accused was sentenced to suffer the imprisonment of reclusion perpetua and to pay the heirs of Selma Pagal moral damages. Okay. On appeal, the CA held that the RTC failed to comply with the requirements of Section 3 of Rule 116 regarding the treatment of a plea of guilty to a capital offense, particularly the conduct of searching inquiry into the accused appellant's voluntariness and full comprehension of the consequences of his plea. Also, the CA observed that the prosecution's evidence was insufficient to sustain a judgment of conviction independent of the plea of guilty. In fact, the CA noted that the prosecution did not present any evidence. Thus, what did the CA do? It remanded the case to the RTC with the directive to follow the mandate of Section 3 of Rule 116. Okay. Now, the accused now filed a notice of appeal to the SC, or to the Supreme Court, okay, pursuant to AM number 00-5-03-SC, which provides in cases where the CA imposes reclusion perpetua, life imprisonment, or a lesser penalty, it shall render and enter judgment imposing such penalty. The judgment may be appealed to the CA by notice of appeal. So, yun ang ginawa niya. Now, so the issue here is whether the appeal to the SC is the proper remedy. Secondly, is whether or not the RTC erred in convicting the accused on the sole basis of his guilty plea despite the failure of the prosecution to prove his guilt beyond reasonable doubt. Okay. To my mind, this is a very important case kasi ang haba ng desisyon ng Supreme Court dito, pero isa talaga niya. Okay? At saka marami talagang teachings. No? Ang sabi ng Supreme Court, the accused appellant availed of the wrong remedy. Hindi daw dapat notice of appeal. In the case at bar, the accused filed a notice of appeal pursuant to Section 13, which we did. But notice here the CA decision annulled and set aside the RTC conviction and ordered the remand of the case to the RTC. Notably, the decision of the CA did not affirm the conviction or the penalty imposed by the RTC. Therefore, Section 3C, Rule 124, is not applicable to the case at bench because the CA did not affirm the conviction of reclusion and the penalty of reclusion perpetua. Instead, accused should have filed an appeal under Rule 45, not a notice of appeal, to assail the CA decision, okay, which expressly provides, except as provided in the last paragraph of Section 13.124, all other appeals to the Supreme Court shall be by petition for review on certiorari under Rule 45. So, pure question of law. Accordingly, the remedy available to the accused appellant to question the CA decision is an appeal by certiorari under 45. It is oft repeated that appeals of criminal cases shall be brought to the court by filing a petition for certiorari under 45, except when the CA imposed a penalty of reclusion perpetua or life imprisonment, in which case the appeal shall be made by a mere notice of appeal to the CA. But the CA nga did not appeal it eh. Ay, sa CA hindi naman niya in-affirm yung decision na reclusion perpetua. Nirima niya. So dapat Rule 45. But nonetheless, according to the Supreme Court, in the interest of substantial justice, this case, okay, the notice of appeal was treated as a Rule 45 petition. Why? Because of several substantive issues. Okay. It must be noted that murder remains a capital offense, despite the prescription against the imposition of death penalty as punishment. In case death was found to be the imposable penalty, the same would only have to be reduced to reclusion perpetua in view of the prohibition against capital punishment of death. But the nature of the offense of murder is still a capital crime, and for that matter, of all crimes properly characterized as capital offenses under the RPC was never tempered to that of a non-capital offense. So capital offense siya, regardless of whether it's reclusion perpetua or, okay, death ang penalty. Okay. Thus, when the accused pleaded guilty during his arraignment, he pleaded to a capital offense. So Section 3, Rule 116 now kicks in. When the accused pleads guilty to a capital offense, the court shall conduct a searching inquiry into the voluntariness and full comprehension of the consequences of his plea and shall require the prosecution to prove his guilt and the precise degree of culpability, and the accused may present evidence in his behalf. Okay. Considering the mandatory nature of Section 3, Rule 116, okay, the duties of the trial court when accused pleads guilty to a capital offense are as follows. Number 1, to conduct a searching inquiry into the voluntariness and full comprehension of the consequences of the plea of guilt. Number 2, to require the prosecution to still prove the guilt of the accused and the precise degree of culpability. And 3, to inquire whether or not the accused wishes to present evidence in his behalf and to allow him to do so if he so desires. What is searching inquiry? Likewise compels the judge to content himself reasonably that the accused has not been coerced or placed under a state of duress, and that his guilty plea has not therefore been given improvidently, either by actual threats of physical harm from malevolent quarters or simply because of the judge's intimidating robes. Further, a searching inquiry must not only comply with the requirements of Section 1, Paragraph A of Rule 16, but must also expound on the events that actually took place during the arraignment, the words spoken and the warnings given, with a special attention to the age of the accused, his educational attainment and socioeconomic status, as well as the manner of his arrest, detention, the provision of counsel in his behalf during custodial and preliminary investigations, and the opportunity of his defense counsel to confer with him. These matters, according to the Supreme Court, are relevant since they serve as a trustworthy indices of his capacity to give a free and informed plea of guilt. Lastly, the trial court must explain to the accused the essential elements of the crime he was charged with and its respective penalties and civil liabilities, and also direct questions to defense counsel to determine whether he has conferred with the accused and has completely explained to him the meaning of plea of guilty. This formula is mandatory according to the Supreme Court, and absent any showing that it was followed, searching inquiry cannot be said to have been undertaken.
Although there is no definite or concrete rule as to how a trial judge must conduct a searching inquiry, the Supreme Court have held the following guidelines should be observed. Ascertain from the accused himself how he was brought into the custody of law, whether he had assistance of a competent counsel during custodial and preliminary investigation, under what conditions he was detained and interrogated during the investigations. This is intended to rule out the possibility that the accused has been coerced or placed under state of duress, either by actual threats or physical harms coming from malevolent quarters or simply because of the judge's intimidating rules. Then the court has to ask the defense counsel a series of questions as to whether he had conferred with and completely explained to the accused the meaning and consequences of the plea of guilty. The judge must also elicit information about the personal profile of the accused, his age, socioeconomic status, educational background, etc. He must inform the accused the exact length of imprisonment or nature of penalty under the law. Okay? In other words, kailangan sabihin kung ano magiging consequences na kakaharapin ng accused pag nag-plead siya ng guilty. It is the duty of the judge to ensure that the accused does not labor under these mistaken impressions, because a plea of guilty carries with it not only the admission of authorship of the crime, but also of the aggravating circumstances attending it, okay, that would increase the punishment, okay. So he has to inquire if the accused knows about the crime, must fully explain to him the elements. All questions posed to the accused should be in the language known and understood by the accused. The trial judge must satisfy himself that the accused is pleading guilty, is truly guilty, hindi dahil sinabi lang ng accused. The accused must be required to narrate the tragedy or reenact the crime or furnish its missing details. Yan yung first duty, yung mahabang yun. The second duty of the trial court is to require the prosecution to present evidence of guilt of the accused beyond reasonable doubt, and that is mandatory. The third duty of the court, okay, is to allow the accused to present exculpatory or mitigating evidence on his behalf in order to properly calibrate the correct imposable penalty. This duty, however, does not mean that the trial court can compel the accused to present evidence. Of course, the court cannot force the accused to present evidence when there is none. So the accused is free to waive his right to present evidence. Okay. Henceforth, okay, according to this case, as I said, this is an en banc case. To protect the constitutional right to due process of every accused in a capital offense and to avoid any confusion about the proper steps to be taken when a trial court comes face to face with an accused or his counsel who wants to waive his client's right to present evidence and be heard, it shall be the unequivocal duty of the trial court to observe as a prerequisite to the validity of such waiver a procedure akin to a searching inquiry. The trial court shall hear both the prosecution and the accused and the respective counsel on the desire or manifestation of the accused to waive the right to present evidence and be heard. Trial court shall ensure the attendance of the prosecution and especially the accused with the respective counsel in the hearing, which must be recorded. Their presence must be duly entered in the minutes of the meeting. And during the hearing, it shall be the task of the trial court to ask the defense counsel series of questions to determine whether he conferred with the accused and whether he was able to fully explain to the accused the consequences of a plea. Okay? Inquire from the defense counsel with the conformity of the accused whether he wants to present evidence. Elicit information about the personality profile of the accused. All questions posed to the accused should be in a language known and understood by the latter. Okay. Now, so applying the foregoing principles, it is evident that the trial court in this case failed to miserably comply with the duties imposed by the 2000 revised rules. As regards the first duty, the trial court failed to conduct searching inquiry to determine the voluntariness and full comprehension by the accused of his plea of guilty. In fact, there are no stenographic notes, okay, which would actually show what really took place, what words were spoken, what warnings were given by the trial court. None. Okay, now, What compounded the RTC's strenuous oversight is the fact that the trial court penalized the accused appellant of the crime charge despite the failure of the prosecution to present evidence of his guilt. Again, this is a direct contravention of the rules of court. No? In this regard, the SC agreed with the CA that accused appellants guilty for the crime of murder was not proven beyond reasonable doubt. It is beyond cavil that the prosecution did not present any witness despite being given 4 separate hearing dates to do so. Thus, the RTC's conviction of accused appellant relied solely on an improvident plea. Okay. Now, so this is where now the Supreme Court issued the following guidelines, which basically are as follows. At the trial stage, when the accused makes a plea of guilty to capital offense, the trial must strictly abide by the provisions of Section 3 of Rule 116. Okay. In particular, it must afford the prosecution an opportunity to present evidence as to the guilt of the accused. Failure to comply with the mandates constitutes grave abuse of discretion. In case the plea of guilty to a capital offense is supported by proof beyond reasonable doubt, the trial court shall enter a judgment of conviction. In case the prosecution presents evidence but fails to prove the accused's guilt beyond reasonable doubt, then the court must acquit the accused, notwithstanding the fact that he pleaded. Okay. So in case the prosecution fails to present any evidence despite opportunity to do so, the trial court shall enter a judgment of acquittal. Okay. Now, appeal stage. During the appeal stage, when the accused is convicted of a capital offense on the basis of plea of guilty, whether improvident or not, and proof beyond reasonable doubt was established, then the conviction shall be sustained. When the accused is convicted of a capital offense solely on the basis of the plea of guilty, whether improvident or not, without proof beyond reasonable doubt, okay, because the prosecution was not given opportunity to present evidence, or was given the opportunity to present evidence, but the improvident plea of guilty resulted to undue prejudice, either to the prosecution or the accused, the judgment shall be set aside and then remanded to the lower court for rearrangement and for reception of evidence. Now, when the accused is convicted of a capital offense solely on the basis of a plea of guilt, but because the prosecution failed to prove the accused's guilt despite opportunity to do so, judgment of conviction shall be set aside. Now, and that's the reason why in this case, the accused was acquitted, okay? Because there was failure to comply with the rules of court. Okay. Actually, I have actually one more slide, okay? And let me just discuss this case of Treyes versus Larlar, okay? Just one case na lang. Again, this is a 2020 case, and if I'm not mistaken, also an NBAC case. Rosie, the wife of Nixon, died. Okay. Rosie, who did not bear any children with petitioner Nixon, died without any will. So Rosie also left behind 7 siblings, the private respondents. At the time of her death, Rosie left behind 14 real estates situated in various locations in the Philippines, which she owned together with petitioner Treyes. Subsequently, Treyes, okay, executed 2 affidavits of self-adjudication, okay, and transferred the estate of Rosie unto himself, claiming that he was the sole heir. The private respondents wrote him a letter saying that, wait, let's discuss about this because they're also heirs, no? Because remember, Rosie died without a will, okay? Now, so then they found out that Treyes pala was able to transfer all the properties in his name. So the private respondents filed with the RTC a complaint for annulment of the affidavits of self-adjudication, cancellation of TCTs, reconveyance and of ownership and possession, okay? Now, Treyes filed a motion to dismiss on the ground of lack of jurisdiction over his person. Okay, remember this was decided under the old rules. He thereafter filed a second motion to dismiss on the ground of improper venue, description, and lack of jurisdiction. RTC denied for lack of merit, again, Treyes' second motion for recon. Nevertheless, the RTC held that it did not acquire jurisdiction on the complainant's third cause of action, that is partition, and ordered the dropping thereof. Okay. CA denied Reyes' petition for certiorari. What is the issue? Whether the RTC has no jurisdiction to hear and try to decide the subject matter of private complainants, given the determination of the status of the legal heirs in a separate proceeding, is a prerequisite to an ordinary suit for recovery of ownership and possession of property instituted by the legal heirs. This actually is a new case because it abandoned, okay, several teachings. This is an en banc case. Okay. Under the Civil Code, when the brothers and sisters of a deceased married sister survived with the widower, the latter shall be entitled by law to one half of the inheritance and the brothers and sisters to the other half. The Civil Code likewise states that this successional right of legal heirs is vested in them from the moment of the decedent's death. Given that the successional rights are conferred by the Civil Code as substantive law, the question to be resolved here by the court is whether a prior determination of the status as a legal or compulsory heir in a separate proceeding is a prerequisite to an ordinary civil action seeking for the protection and enforcement of ownership rights given by the law on succession. And this, I quote the court now definitively settles the question once and for all. Okay. It is clear that the status of the private respondents as siblings of Rosie was not refuted by Trenes. Okay. He also did not make any allegation that the birth certificate of the private respondents are fake and spurious. So it's settled. But all he said was, okay, and his only defense was, all he says is there must first be a declaration of the private respondent's heirship in a special proceeding. In fact, Reyes did not contest the due execution and authenticity of the respondent's birth certificates. Ang sabi lang niya, kailangan munang ma-determine sa separate proceeding na talaga kayo ay tagapagmana. Hence, according to the Supreme Court, despite the promulgation of Ipon, Chinchay, Portugal, Reyes, and other cases upholding the rule that a prior determination of heirship in a special proceeding is a prerequisite to an ordinary civil action involving heirs, such rule has not been consistently upheld and is far from being considered a doctrine. To the contrary, a plurality of decisions promulgated by the court and bank and its decisions firmly hold that the legal heirs of a decedent are the parties in interest to commence ordinary civil action arising out of the rights of succession without the need for a separate prior judicial declaration of heirship, provided, and this is very important, the proviso, provided only there is no pending special proceeding for the settlement of the decedent's estate. So the more recent strand of jurisprudence correctly recognized the legal effects of Article 77 of the Civil Code and thus actually provide for remedies for the heirs to protect their successional rights, okay, over the estate of the decedent even prior to the institution of a special proceeding for its settlement. By this decision now, the court so holds and firmly clarifies that the latter formulation is the doctrine which is more in line with the substantive law. Okay, Article 777, which is clear and unmistakable in stating that the rights of succession are transmitted from the moment of the death of the decedent even prior to any judicial determination of heirship. As substantive law, its breadth and coverage cannot be restricted to or diminished by a simple rule in the rules. Okay? Now, hence, okay. So in other words, okay, there is no need for a separate judicial determination in a special proceeding as a precondition in an ordinary civil action where heirship is already established by compulsory succession or by intestacy. Okay? Now, okay. So to recap, according to Supreme Court, ang nagbigay pa ng recapitulation ang Supreme Court. Given the clear dictates of the Civil Code that the rights of the heirs to the inheritance vest immediately at the precise moment of the decedent's death, Even without judicial declaration of heirship, the various court and bank and divisions holding that no prior declaration of heirship is necessary before an heir can file an ordinary civil action to enforce heirship rights acquired by virtue of succession through nullification of deeds divesting property or properties forming part of the estate, thereof to the estate or for the common benefit of the heirs of the decedent. The court resolves to clarify the prevailing doctrine. Accordingly, the rule laid down in Ipon, Yaptinchay, Portugal Reyes, heirs of Gabatan versus CA, and other similar cases, which requires a prior determination of heirship in a separate special proceeding as a prerequisite before one can file an ordinary civil action to enforce ownership, acquired by virtue of succession, is abandoned, sabi ng Supreme Court. Henceforth, the rule is, unless there is a special proceeding for the settlement of the decedent's estate or for the determination of heirship, the compulsory or intestate heirs may commence an ordinary civil action to declare the nullity of an instrument or deed and for the recovery of property or any other action in the enforcement of their ownership rights acquired by virtue of succession without the necessity of a prior and separate judicial declaration of their status as such. The ruling of the trial court shall only be in relation to the cause of action of the ordinary civil action, that is, the nullification of a deed or instrument and recovery of reconveyance of property, which ruling is binding only, between and among the parties. At exactly 6 o'clock, I would like to thank everybody for joining us in Caso Discurso. Secondly, and before I leave, I would like to remind you of the best formula ever for passing the bar. Study as if you've never studied before and pray as if everything depended on God. And may God be with you as you journey, and claim your rightful place in the legal community. Thank you very much. I'm sorry, I cannot hear you. I think you're muted, ma'am. I cannot hear you. Meg, I'm sorry, I think you're muted.
Hello, Dean Sol?
Yes, thank you.
Ayun po. Thank you very much po, Dean Sol, for this afternoon's lecture. Of course, as bar takers, we are truly grateful for legal luminaries like you who share their time in order to help us prepare for the bar. Just a few things lang po before we end. We would like to address some of the comments, some questions or clarifications lang po, if I may, Dean.
Yes, please.
Okay po. First question po is from Mr. James Malyari. How will you reconcile or classify po if the amount is 400,000, since in summary procedure the amount is 400,000 and in small money claims it is also in the amount of 400,000 as its maximum?
In the first place, all you have to do is look at the scope. When you talk about small claims, kanina nilagay natin doon, it's for reimbursement of money or claim of sum of money under contracts such as contracts of lease, contract of sale, nakalista doon, no? Ang scope. Ngayon, pagpapansinin po nyo, wala ho doon damages. Walang based on tort. Kaya kung based on tort, wala yun sa scope ng small claims, ibig sabihin nasa revised rules and summary procedure siya. So ang titignan po nyo lagi dapat will be the scope.
Ayan. Another question po from Mr. Paulo Olero. Dean, does the general prohibition to file a motion for extension apply to petition for review on certiorari and or petition for certiorari?
The motion for extension of time under Rule 45 is allowed. It is allowed. It's allowed, yeah. Okay.
This one, I think it's not a question on the lecture po. Greetings of love and peace. Can I still watch this lecture? Yes po, you can still access this lecture in the Pulse Facebook page even after this event. Do we still have comments from... For those asking naman po, just like to address, for those asking for the PowerPoint of Dean Sol, please check the Facebook page of Pulse na lang po in the coming days on how to get it. Ito po, question po. Okay. From Miss Jenicel Kadungog. Good afternoon po, Dean. I would like to ask if the defendant filed his answer on the last day as allowed by the court, and if denied, what is his remedy under the new rules? Thank you, Dean, and God bless you po.
Okay, I think, Jencel, I think when you file the petition, when you file your answer on the last day, the court should not deny it, okay, because you filed it on time. But in the remote possibility that the court will deny, the court cannot deny it motu proprio. Somebody has to file a motion to strike out the answer before the court can make a ruling on it. Now, in the remote possibility that somebody files a motion to strike the answer for or expunge the answer for being filed out of time, despite the fact that it was filed on time, and the court grants the same, okay, then you file a motion for reconsideration first. Okay, file a motion for reconsideration. Let the court first correct itself. Okay.
Okay. Another question this time from Ms. Lira Perez. Dean, good afternoon po. Is a motion for reconsideration or an MR mandatory for every case before filing an appeal to the RTC or CA as the case may be? Thank you.
As a general rule, the filing of a motion for reconsideration, okay, before you appeal is not a prerequisite for you to appeal, except in cases for petitions for on judgments rendered on petitions for declaration of nullity of marriage, annulment of marriage, and legal separation. Base po sa AM number 02-11-10, you are required to first file a motion for reconsideration before the RTC that rendered the judgment, and after its denial, then you can now appeal to the CA.
Ayan, there you go. Do we still have comments po? Oh, I think these are thank you and appreciation comments po, Dean, from Mr. James Malyari, the one who asked a while ago. Thank you very much for the clarification po, Dean. Another from Mr. Cresglo, Einstein Gernale Capidos. Thank you once again, Dean and Pulse, as you did last summer of 2020 during the lockdown, for enlightening me. And ayun, another thank you message from Ms. Lira Perez.
Thank you very much, and I hope you learned something today. I think some of our videos on last year, because it was mentioned by one of the attendees, I think it's still posted in the Pulse FB page.
Yes po. For our viewers, if you want to access, just scroll down po. They are still posted in the Pulse Facebook page. At this point, thank you po again, Dean Sol. We will just
Maraming salamat. And thank you very much to Rex, to Central Bookstore, to My Legal Wiz. Thank you for helping Pulse reach out to our bar examinees. Okay? Yes. Thank you very much and good night.
Thank you, Dean.
Bye-bye.
We will also be sending a certificate of appreciation to Dean Sol. We would just like to show it. The certificate of appreciation for Dean from the Philippine Association of Law Schools and also from the PUP College of Law. This certificate is being presented to Dean Maria Soledad de Requito Mawis for imparting her invaluable knowledge on the subject matter of remedial law during the 4th edition of Caso Discurso, a discussion on the latest Supreme Court decisions given this 6th day of September 2021. Signed by Attorney Jemmy Lito Festin, President of Pulse, and the Dean of the PUP College of Law. Now, thank you everyone. Thank you for the viewers for staying with us until the end. And please watch out for the next Caso Discurso event, which will be on September 13, Monday again. And it will be on commercial and criminal law naman po. Also, please stay tuned for the upcoming webinars as well, which will all be on the Mondays of September and October. This has been your host, Meg Reyes, and again, this event is brought to you by the Philippine Association of Law Schools, together with PUP College of Law, and in collaboration with Central Books. Again, this event would not be possible without our sponsors, Rex Education and My Legal Wiz. Don't forget to give some stars if you think this lecture was helpful. Again, thank you everyone. Best of luck to the best bar takers ever. Stay healthy and stay safe. Thank you.